Well, good morning, everybody. Welcome to Making Law Simple. My name is David Helm, a licensed practicing attorney in the state of Michigan. And we are done. Request denied. Welcome, everybody. Though we are going to talk about the James Crumbley trial, or motion hearing, rather. And I have a feeling the motion will be denied. If you've been following this channel for a little while, you know that I've been covering the James and Jennifer Crumbley trial and conviction involving, I guess, somehow they're involved with the Oxford school shooting. They're supposedly guilty of it. And because they didn't take actions necessary to protect society at large from their son, Ethan Crumbley. Dave's smoking. Am I smoking? I don't know. I've been sitting up here for a little bit, sort of preparing for this, and then I'm at a loss of words for this stream. But welcome, everybody. I see Whiskey in the chat. Jung is in the chat. DK Cripple, welcome. Chris. And we have Upon the Horizon over in Rumble. And Doug Carter. I don't know if Doug Carter is still here. What's this? This is the James Crumbley motion hearing for a new trial. That's what we're going to be reviewing today. And, Dark Matter, Mads, welcome all, welcome. So let's give a brief overview of the Crumbley case. In November of 2021, Ethan Crumbley, then age 16, goes in and shoots and kills 4 students in his school, injures various other people. I think a couple of teachers were also injured as well. And he was charged as an adult and pled guilty as an adult and has since been sentenced to life in prison. In the meantime, his parents, James and Jennifer Crumbley, were also charged with involuntary manslaughter and were subsequently convicted, and they are spending approximately 15 years each in prison for that. Jennifer Crumbley brought a motion to set aside her trial, or set aside her conviction and for a new trial, based in part on the fact that there were proffered agreements offered to 2 key witnesses in her trial that were not disclosed to the defense. The Jennifer's attorneys argued that it was a Brady violation. And they argued it a little bit differently in their motion than James' attorney did just this past Friday, which was interesting that they they specifically call out the difference in the arguments. And I really like what James' attorney had to argue. I don't think it's going to be successful. I think ultimately it's going to get denied just because of the nature of this case. The judge during the hearings a few times we'll pull them up shortly, referenced the Court of Appeals. That's for the Court of Appeals to decide, sort of thing. But it was a really interesting argument, and we're going to talk about it. I also wanted to talk about the sanctions. There's some talk, the news media, right? Let me actually, before I pull up the stream, let me pull this up. So part of Jennifer Crumbley's motion, or there was a motion on behalf of Jennifer Crumbley by Jennifer Crumbley's attorneys to remove the prosecutor from Jennifer's case. And in response to that motion brought by Jennifer's attorneys, the judge sanctions Jennifer Crumbley's lawyer for trying to kick prosecutor off case. This is how it reads. Now, we normally think of sanctions is like the attorney has to pay some fee or something along those lines. This sanction is simply, this is a public appointed appellate attorney. And the sanction is simply that the attorney who brought the motion is not going to get paid for bringing the motion. That's the sanction here. So while Matthews, that's the judge, has not yet ruled on Crumbley's appeal, she sanctioned Desi, I guess, in the following way. He will not be reimbursed the money he spent preparing and filing the motion to disqualify Karen McDonald. That's it. He's like, okay, fine, whatever. I'm not going to get paid. That's the extent of the sanction. It's not severe sanctions. He's not getting reprimanded by the judge. There's nothing like that. It wasn't an improper motion in my mind, although the judge declared that it was an improper motion and sanctioned him. But his sanction was simply, you're not going to get reimbursed for your filing fees and the time you spent in filing this motion. Again, a public appointed attorney is not going to get paid for this motion. It's not that big of a sanction. But the headlines were, attorney sanctioned. So I wanted to talk about that just a little bit and just bring that story full circle before now we'll get into the hearing. The hearing lasts about an hour and a half. I will probably interject as I normally do. And I think everything will go good. Yeah, that's what I was saying. The headline is pretty misleading then, right? It's like attorney sanctioned for trying to oust prosecutor. And it's like, all right, the judge said you're not going to get paid on this one. That's all. Factual lie. Welcome. Totally Pip. Good afternoon. And Wendy H is in the chat. And let's not forget Dolly. And of course, now my neighbors break out the leaf blower. So hopefully it's not too distracting. But let's get going with this. I really like these arguments. I have it on 1.25. I also have the sound boosted. So you guys let me know if there's any issues with it.
All right. Today is the date and time set for defendant James Crumbley's motion for a judgment of acquittal or in the alternative a new trial. As has been this court's practice in each hearing over the past 3.5 years, the proceeding is being conducted in person. In keeping with that procedure, we alerted all parties that defendant James Crumbley would be writted from the Michigan Department of Corrections. Ms. Sharon then indicated to my chambers that the defendant did not wish to be brought here for these proceedings, as is his right. Ms. Sharon also requested that her client be permitted to participate by Zoom. The court indicated that there would be that we would make that request to the Michigan Department of Corrections. We also obviously have more ability to control that at the Oakland County Jail.
This is Judge Matthews. And what she's talking about right here is that James Crumbley is not going to be present for this hearing. He did not want to be. Okay, so this is maybe like a lot of people don't understand this. So the Michigan Department of Corrections, the prison system, is so much better than your local county jail. I don't care if it's Oakland County, which is the richest county in the world. It's so much better. I don't know exactly where he's being housed, but he did not want to sit on a bus for a day to be transported to Oakland County Jail to sit there in a holding cell and then, go to court and then spend another day traveling back to the prison. He's like, just leave me. Just leave me in prison where the conditions are so much better. And you go ahead and argue for me.
But we were unsure about whether the Michigan Department of Corrections would accommodate a Zoom hearing with the defendant that can potentially be lengthy. The Michigan Department of Corrections has accommodated that request to the extent that Mr. Crumbley will be able to see and hear these proceedings. And Ms. Sharon, I think you've indicated that Mr. Crumbley, although he has the right to be present for this hearing in the courtroom, that he's willing to waive that right to be present in court.
Absolutely, Your Honor. As the court has correctly indicated, it was our request that he appear by.
This is James's appellate attorney, court-appointed appellate attorney. I don't remember her name, although I like her arguments quite a bit. And then, there was another Oakland County judge. There's been a couple of Oakland County judge mishaps over the last few years. There's a current Oakland County judge that was sneaking in trying to get a hold of her stuff after she was removed from the bench with pay for a little while.
Zoom, so I would waive his appearance for purposes of this hearing.
All right, thank you. I wanted to indicate before we got started that I'm not in the habit of issuing late opinions. I tend to keep up with my responsibilities, so I wanted to let you know that I thought it would be appropriate to not issue an opinion on the remaining issue in the Jennifer Crumbley matter until hearing oral argument in this matter. So I will get back to you as soon as possible with regard to that.
Thank you, Judge.
All right. All right. So,
It's interesting. The judge says that I didn't want to issue an opinion on Jennifer Crumbley's motion until I heard oral arguments on this, and then catches herself. And I believe the attorneys correct her later on about how you can't say one argument can be used for both cases. You got to take them independently. And the judge is like, I know.
I'm going to ask you to all please be mindful that I've read and thoroughly reviewed the motion filed by the defendant, the response filed by the Oakland County prosecutor, and the reply filed by the defendant. In fact, I read the entire guidepost report as well. I think it'd be helpful if we went issue by issue with Ms. Sharon giving her argument, the prosecutor responding, then Ms. Sharon providing any reply. All right, so Ms. Sharon, it's your motion. You can address each issue raised in your motion in any order you see fit. All right.
Your Honor, before I begin, when I typically argue in front of the Court of Appeals, I don't always touch on every issue that I've briefed, and I did not intend to do so today.
I'm so relieved.
I'm glad I could make your day, Your Honor.
Yeah.
So as long as that is acceptable to the court.
Oh yeah, I
but
have
if you're
read
invited,
everything more than once
I
and have pulled the
trust that.
cases and read the cases. I think oral argument is important, but I would appreciate hitting the highlights. You did an outstanding job on your brief, and it is very detailed.
Lengthy.
But it is Friday, and I don't want to be here till 10 o'clock at night. So.
I understand, Your Honor. So I will proceed as I had planned.
Okay.
But of course, if the court has questions on any of the other issues, I'm always more than happy to answer those. Again, Alona Sharon on behalf of Mr. Crumbley, Your Honor. Mr. Crumbley is entitled to a new trial for a number of reasons, the least of which is the concealed proffer agreements. And so, Your Honor, I want to start off this morning by talking about the court rule, the discovery rule that's at issue.
Yeah, this is the judge that's handled everything involving James and Jennifer Crumbley. This is not the same judge that handled the trial or the sentencing for Ethan Crumbley, the child.
Here, which is, of course, MCR 6.201B5. Your Honor, the prosecution would read the court rule so that the phrase, quote, for testimony modifies all terms of that subsection. So it would modify any plea agreement, grant of immunity, or other agreement. But the prosecution's suggested reading of the court rule does not comply with our rules of statutory interpretation, rules of grammar and punctuation, and perhaps most critically, Your Honor, it does not comply with the purpose of the court rule. First, Your Honor, the court rule is not ambiguous. The use of commas in B5 separates each clause such that the rule requires the prosecution to disclose any plea agreement, 1, 2, any grant of immunity, or 3, other agreement for testimony in connection with the case. But if Your Honor does find that the court rule is ambiguous, then it should look to the rule of the last antecedent. And under the rule of the last antecedent, Your Honor, the clause for testimony modifies other agreement and not the first two phrases, plea agreement or grant of immunity. Under the rule of the last antecedent, Your Honor, and just general rules of punctuation, a comma would have to be inserted after or other agreement to reach the prosecution's reading. So essentially what the prosecution is asking Your Honor to do is read a comma into the rule that isn't there.
Remember, this judge sat on the rule-making committee, so she knows.
The drafters of these rules are familiar with rules of punctuation.
I think she sat on the rule-making committee.
But the most compelling reason, Your Honor, that the prosecution's reading of the court rule must fail is because it's not supported by the purpose of the rule. MCR 6.201B5 is born out of Brady versus Maryland, Your Honor, 373 U.S. 83. That case requires a prosecutor to, quote, disclose any information that would materially affect the credibility of his witness. In People versus Atkins, 397 Mich. 163, our Supreme Court stressed that the focus of requiring disclosure in such situations is to reveal factors that the jury may consider in weighing a witness's testimony and which may motivate the witness to give certain testimony.
Well, let me ask you this.
Yes.
I don't want to mess with your mojo because you're sort of on a roll
Don't
here,
worry.
but
I've got more mojo than I can handle
okay,
right now.
so what if I agree that the prosecutor violated the rules with regard to discovery?
I'm gonna speed this up just
What
a
if I
little bit
agree
because she
with
talks
that?
slow.
So where does that take us next?
Yeah, so
Sure.
so you're telling me about a Brady violation, but
No.
what is the remedy? What is the remedy if there's a violation of the rules of discovery? Just plain old 6.201B2.
Sure, Your Honor. And I will answer that question in 10 seconds.
Okay.
I do just want to point out, because I feel like when the other defendant's case was argued, there was this sort of conflating of discovery violation versus Brady violation.
They're separate.
But okay, and I believe that Your Honor understood that concept. I just didn't feel like it was super clear on the record. So right now, I'm addressing the discovery violation. So as to your question of what is the remedy, right? What is the sanction?
Because then you started telling me about Brady, so I agree with you that they're separate.
So, Your Honor, I referenced Brady because
Kudley is in Rumble.
6.201B5 is drafted in the spirit of Brady. It is drafted in the spirit of protecting a defendant's right under Brady, but they are two different claims.
Okay.
As to the sanction or the remedy, Your Honor, so we look to 6201J, right, that talks about violations. And under the court rule, as well as the applicable case law that's cited in the brief, Your Honor has wide discretion to grant an appropriate remedy or sanction. And Your Honor should be guided by a variety of considerations. First, if you just look at the plain language of 6201J, it lists several examples of remedies that Your Honor could use, except none of those would be helpful in this case because the prosecutor didn't disclose until following conviction. So then you keep reading, or enter such other order as it deems just under the circumstances.
And you're saying that would be a claiming trial?
Absolutely, Your Honor, because it is the only way to make Mr. Crumbley whole. It is the only way to correct the violation of the court rule. If someone
What other way is there? Does anyone in chat have a good idea as to how you can fix this? So if a prosecutor violates Brady, which is not disclosing evidence or information that could be beneficial to the defense, what is the other remedy? Now, in Jennifer's case, they asked for an acquittal and to like dismiss the case. That's a remedy, but a better remedy would be a new trial, right? And allow this evidence to come in. That seems like the only appropriate remedy to me.
Some other sanction that could remedy this wrong, I'm happy to hear it, but there isn't one.
Thanks,
right?
Wendy.
And that's why the prosecution has to keep hounding this argument that they didn't have to disclose this immunity proffer agreement, Your Honor. Your Honor, I guess I would ask you if you are at the point where you feel like this was a violation of the discovery rule.
I like to do.
Okay. I can take the message that Your Honor is telegraphing, Your Honor. I do want to remind the court that back on January 31st, when Jennifer Crumbley's case was being argued, Mark Keast argued to this court that his office did not have authority to grant immunity outside of statutory immunity. That's a direct quote. The only way to grant immunity is to petition the court. It now seems—
You're talking about oral argument on Mrs. Crumbley's motion?
Yes, Your Honor.
Okay.
And I do cite to it, I believe in the brief.
Oh, you're talking about this year, not talking about the trial. Yeah.
Correct,
Okay.
Your Honor.
See, that's the thing, is that they argue, the prosecutor argues alternative theories, legal theories, as well as factual theories throughout this entire case. They argued something completely contradictory to the James and Jennifer Crumbley trial when they were trying to sentence Ethan Crumbley, saying like it was 100%. He can't put the blame on his parents. He needs to be sentenced to life. And then turn right around and say, oh, well, now in their case, they absolutely have to be responsible. You can't put the blame just on Ethan. And then they're doing the same in the Jennifer Crumbley motion versus the James Crumbley motion.
So it's remarkable, and it should be remarkable to this court, that it appears at this point in time they've abandoned that argument, Your Honor. It's nowhere in their response brief. I don't know what Mr. Keast will argue today, but they absolutely do have the authority to bestow immunity outside of statutory immunity, and that is what this argument was. So to go back, Your Honor, to the remedy, I do want to talk a little bit more about that. According to our case law, when Your Honor determines the appropriate remedy for a discovery violation, you must consider and balance the interests of the courts, the public, and the parties in light of all the circumstances, including the reasons for noncompliance. Your Honor's paramount interest is that the discovery should facilitate the search for the truth. The public's interest, Your Honor, is that when a trial concludes, it can have faith in the outcome of the trial. And obviously, a party's interest is that it be able to properly prepare for trial. And the court should also consider whether the objecting party was surprised. Every single person in this courtroom, with the exception of 4 people, were surprised, Your Honor, by the existence of these proffer agreements. In People versus Taylor, 159 Mishat 468, the court instructed that the first question for Your Honor to answer when fashioning a remedy is whether the party's interest in preparing his own case or his opportunity to test the authenticity of a witness or the authenticity of evidence has been prejudiced, which it has been here, Your Honor.
Can I ask, I want to ask you about Taylor, but
Yeah.
Can I ask you what kind of immunity you say that they conferred? Because it's not transactional, right? And with regard to use immunity, doesn't use immunity protect a witness against compelled testimony? There was no testimony compelled by either EJAC or Hopkins. I think your brief says pocket immunity. I don't know. So what flavor are you alleging?
So I don't know, Your Honor, that there has to be a specific title to the type of immunity, but the case law is cited in the brief that references, right, pocket immunity is one of the phrases, informal immunity. But the case law is clear that where a promise is made in exchange, even just for cooperation, that is a form of immunity, Your Honor. And here, obviously, the plain language of the proffer agreement promised Hopkins and EJAC that any evidence or information that was provided to the prosecution during these proffer meetings could not be used against them in the prosecution's case in chief.
Okay.
So that is, I do agree. I guess I respectfully disagree that it's not use immunity, but even if you don't want to give it that proper title, it certainly is a form of pocket or informal immunity, which would still be required to be disclosed under Brady and under the court rule, Your Honor.
Okay. Yeah, but I don't know. I think use immunity is when the testimony is compelled. EJAC and Hopkins still don't have to testify, right?
No, they certainly were not required. I mean, they were subpoenaed. Mr. Keese indicated that at the last hearing. So obviously they were required to appear. But I think everyone agrees that they probably could have asserted the Fifth Amendment.
They probably would have.
Correct, Your Honor. The second consideration under Taylor.
So the judge is acknowledging that without the agreements, the 2 witnesses, EJAX and whatever his name is, this is the school, the assistant principal, the disciplinary dean, or whatever you want to call it, and the school counselor, they would have asserted their Fifth Amendment, but for this agreement. So the judge just acknowledged that.
Is that what remedy may be appropriate giving due regard to the competing interests of the party, the court, and the public. And Your Honor, I want to take a moment here to address the Dickinson case that's relied on by the prosecution in its response, because the procedural facts of Dickinson are very different here. So in Dickinson, we have admittedly a discovery violation that comes to light during the trial. And instead of asking for a sanction under the court rule, the defense counsel in Dickinson simply moved for a mistrial, which is a different claim. And the review of the Court of Appeals in Dickinson is a review of a trial court's authority to grant a mistrial and whether the granting of a mistrial is appropriate. That is a different set of law. That is a different analysis. So Dickinson is really wholly inapplicable to the case that's before Your Honor today.
Well, you mentioned Taylor, but in Taylor, U.S. Supreme Court case, the Supreme Court affirmed the trial judge's exclusion of a defense witness not included in discovery, and there was some other
I was just going to get to that case.
That happened.
Yes.
Right, but that was kind of the easy button there, right? Because it was that witness was going to commit perjury. There was some underhandedness, and the witness wasn't disclosed at all, right? And the witness was going to perjure himself. In this instance, we don't have a witness that's undisclosed, right?
Correct.
EJAC and Hopkins were.
Yeah, that's what was argued in the. I don't like this position. That's. Geez. Okay, hang on. That is what was argued in the Jennifer Crumbley's case, is that the witnesses were not essential. And I think they were very essential. And I think the judge hasn't issued a ruling yet on that. But yeah, she was going to try to say that they weren't essential. And therefore, all of this talk about their testimony and whether or not they would have pled the Fifth and not testified is immaterial.
On the witness list from the beginning, they testified at preliminary examination, right? So Taylor's a different scenario, isn't it?
Your Honor, and I don't use Taylor for the purpose of the facts being necessarily on point, but what the case stands for. May I address that?
Sure.
Okay. So, and Your Honor has touched on this a little bit, but just to kind of reiterate the basic facts in Taylor, the defendant Defense counsel at the first day of trial moved to amend his witness list to include 2 witnesses, one of which he said was much more critical than the other, and reason that he didn't provide the name in a timely fashion and pursuant to the discovery order was because he had trouble locating him, so he didn't have an address, and that the witness had seen the entire incident from which the criminal charges stemmed.
And both of those things were lies.
Correct. That is correct, Your Honor. So the judge tells the lawyer, bring your witness in tomorrow. I'm going to make inquiry and I'll make a decision. But what is remarkable in Taylor, Your Honor, is that you have a defendant who has a constitutional right, a due process right to present a defense, a constitutional right under the compulsory process clause to present evidence that is favorable to him. And despite those guarantees under the United States Constitution, the United States Supreme Court affirmed an incredibly severe sanction, Your Honor, incredibly severe. Okay. So what do we take away from Taylor? If the violation is intentional, okay, if there is bad faith behind the violation for the purpose of gaining a tactical advantage, a severe sanction is warranted. That's what we take away from Taylor. And Taylor said that the court can consider whether compliance with the discovery rule is onerous or relatively simple. Your Honor, Mr. Keese provided discovery to defense counsel 34 times subsequent to the signing of these proffer agreements. On 34 separate occasions, he consciously decided to continue to conceal these proffer agreements that he was required to disclose under Brady and under the court rule. It was intentional, it was willful, and despite the fact that I frequently forget to attach things to my emails, it was an easy thing to comply with. It would have taken 5 seconds, Your Honor, but he didn't do it. So because the violation is intentional here and willful, it is deserving of the harshest sanction. But Mr. Crumbley isn't seeking the harshest sanction, Your Honor. He is seeking the one and only sanction that can right the wrong, that can make him whole, and that is a new trial, Your Honor. Anything short of that, and there is no correction to the misconduct, Your Honor. So again, the court is to consider the reason for the failure. So what does the prosecutor's office argue? One, they first argue that it's something that they didn't have to disclose. I really hope by now the court is not taken by that argument. The second reason that they initially argued was that it was never an immunity agreement because they can't bestow immunity, which, Your Honor, the case law.
Well, sorry, guys.
Cited in my initial brief clearly dispels that argument. The reasons put forth by the prosecutor are incredible, and they should not persuade this court to conclude that the misconduct was unintentional. Your Honor, the prosecution team consists of 83 years of legal experience. Karen McDonald, 26 years, and a former judge. Mark Keese, 19
He is a former
years.
judge. She
Dave
should know
Williams,
better.
29 years. Joseph Shada, just under 10 years. 83 years of legal experience, Your Honor. Your Honor cannot really believe that 83 years of experience and this team did not know that they could bestow immunity on Hopkins and Ejak, that those agreements in fact bestowed immunity and that they were required to disclose them. Your Honor, I want to turn now to the prejudice issue. So if you look at Davey, which is companion, it's Davey and Obispo. So they have an evidentiary hearing in that case when do you have a question?
No, it's incredible to me and Davey, but the defense attorneys had to go to the Detroit Police Department to get their discovery.
I don't know that that's so unusual, frankly.
Well, no, but I mean, completely. It seemed dark ages.
Oh, you mean that they didn't receive it via email?
Or no, not email, just, I don't know.
Well, Your Honor,
You called the Detroit Police Department,
so to turn to the prejudice,
There was no discovery there, though. No, it was zero. None.
that is correct.
Right.
But if you look at Davey, Your Honor,
It's prejudice, capital P, right?
I don't know what you mean by that.
Well, they weren't given any discovery.
Correct. But the court in Davey, okay, never makes a finding that the failure to produce the discovery was outcome determinative. All it does is the trial court took testimony from trial counsel who testified that their ability to prepare was compromised, and that was enough prejudice. That is the prejudice that is required, Your Honor, under the discovery claim. And so let's talk about the prejudice in this case, Your Honor. James Crumbley was prejudiced because he was unable to effectively cross-examine the witnesses as to their bias and motive. He was unable to fully prepare his case, but perhaps.
Yes, if they can establish that if the court determines that the prosecutor acted in bad faith, they could issue an acquittal, essentially a directed verdict, and then dismiss the case with prejudice. But they're not going to do that. What this is going to end up in, best case scenario, is a new trial.
What's most compelling, Your Honor, is that I reference in the reply brief the audio from Mr. Hopkins' initial interview, right?
I listened to it.
The day of the shooting. When you listen to that audio and compare it to the testimony that he provides at trial, subsequent to the proffer agreements, there are distinct differences, Your Honor. Nothing in his interview to the police expresses frustration with the Crumbleys' unwillingness to take their son home. There was no mention that they refused to take EC home.
Seems very material and different from the testimony.
He explicitly says, Your Honor, in that audio, the parents were absolutely on board to get him help within 48 hours. And he also tells the officer, look, these parents, they know that their son has a tremendous amount of anxiety when it comes to missing class. So much so that he tells the officer that James Crumbley told him he wanted to plan a family vacation and EC was going to have to miss class for it, and told his dad, I don't want to go on the vacation. I cannot miss school. I cannot miss class. So you go from these statements that he makes right within hours, okay, of the shooting, where he does not express any frustration with the Crumbleys, any concern about James Crumbley, that he is disinterested, that this meeting ends abruptly. And when you compare, Your Honor, those statements to the officer shortly after the shooting and his testimony, where he talks about the meeting ending abruptly, the parents not acting appropriately with EC, and I detail it all in the brief. I don't think I need to.
So essentially what she's doing is she's going over exactly what I talked about during the trial, at least the ones with Jennifer, that the parents, there was no concern by the school for Ethan to stay in school, that the parents were attentive, that the parents were addressing the issues, and that no blame was being placed on the parents at the onset, except by the prosecutor's office. And I believe that this is most likely a very political charge, not necessarily a motivated by the interest of justice. But for the testimony to change so substantially from their initial statements after a proffered agreement was made, I think makes the proffered agreement extremely material. And this should result in a new trial. We'll see what the judge has to say.
Repeated. But not disclosing the proffer agreements, Your Honor, it robbed him of the inference that this gentleman's testimony shifted as a result of the proffer agreements, Your Honor.
Okay, well, this meeting was 12 minutes long, right?
I believe it was 20, but 12.
Mm-hmm.
Yes. But the officer asked him repeatedly about the meeting, about the parents. How was the child doing? Were they willing to get treatment for their son? And Mr. Hopkins expressed no concern about the parents, not one shred of concern.
You don't bring a trial focused on the sentence. They're going to get sentenced to what they were already sentenced to if they're convicted. You don't want the conviction, Dolly, so you focus on that.
Concern, not one observation in that interview about their conduct during that meeting, about their attitude during that meeting. Your Honor, we know that without the proffer agreements, Hopkins and EJAC would not have testified. That is a reasonable inference given their lack of cooperation with the Guidepost investigation. They had no interest in transparency.
For reference, the Guidepost investigation was an investigation carried out by a private investigation firm hired by the insurance company, which is all wrapped up, and there's a separate civil suit involving the insurance company for the school and all of this stuff. And the two witnesses did not cooperate in that investigation, and there's a bunch of civil litigation going on regarding the insurance coverage and payouts to the families of the students and things like that. And so that's what she's referring to, is that these two did not cooperate in that investigation.
And their interest was self-preservation.
Okay, but the prosecutor would say that everybody's interest is self-preservation, right? So they were incentivized to shine themselves up before the proffer agreement, during the proffer agreement, and after the proffer agreement.
Sounds familiar, huh, Long Call?
Any reasonable person avoids being charged with a crime, right?
100%, but not every person is a witness in a criminal trial. That's what matters here, right? What gives them the bias and the motive to have that shift in the way he characterizes his interaction with James's interaction with
I've got another story.
Their willingness to get this child help.
If you guys stick around to the end of this, I've got another story involving a different prosecutor here in Michigan and potential charges against parents that we're going to talk about after this.
Here's the distinction, Your Honor.
He talks about it when he's being interviewed by Joe Bryan at the jail too, right? There's an interview with Joe Bryan at the jail
between
Mr. and Mrs.
and the child
and the two defendants. A lot of those things are stated there.
Are you talking about the exhibit? The
It's
exhibit that's
two to the
attached?
It's exhibit 2.
Yes, Your Honor, I reviewed that twice. There is nowhere in that interview where the Crumbleys indicated that they had to leave to go to work. That is not in there. There is nothing in there.
They do leave to go to work, right?
Your Honor, the point is that the prosecution tries, but the reason that they leave, Your Honor, and they leave EC at school, in that initial interview with Hopkins, he makes clear that those parents wanted EC to stay in school, Your Honor, because they had serious concerns about the amount of anxiety he experienced from missing class. And that's confirmed by Hopkins. He talks about in great detail how much the students have struggled because of COVID, and that EC seemed to struggle a lot from not being in school. His grades had declined a bit from that, and his parents confirmed that not being in class was incredibly anxiety inducing for him.
Wasn't he sleeping in class at some point?
I believe that is a statement that he might have made to the CFP, and a teacher might have reported it.
That's fine.
But regardless of that, I don't think it's disputed that EC reported and his parents acknowledged that not being in school was incredibly difficult for him and that he wanted to stay in class. So you go from Mr. Hopkins telling the officer, these parents were on board, they wanted to keep him in school because they knew he would be upset if they took him out of school, to this shifting narrative at trial that no, they didn't want to take him because they didn't want to be bothered and they didn't really think he needed help, and so on and so forth. That is a remarkable shift in the characterization and the narrative of the Crumbleys, specifically James Crumbley and his conduct in that meeting, Your Honor.
Okay, but regardless, that doesn't change. Whatever EJAC and Hopkins say doesn't change the fact. It doesn't change what happened.
Well, it changes the testimony, Judge.
There's videos, there's all kinds of things that happened before and after.
Your Honor, I don't dispute for one moment. They came
She
there.
didn't want to come at first, Mrs., right? And said she couldn't miss work, and then she comes, and they're there.
It has nothing to do with this case, Judge.
Nothing EJAC and Hopkins.
Has nothing to do with James's case.
Your Honor, the facts might not change, but the way that they're characterized and the narrative that's given around the facts, right? That's what's important. And that's what the prosecution used Hopkins for, in part, was to give testimony about how they conducted themselves in that meeting. The fact that they seemed almost irritated about having to be there. The fact that the meeting, quote, ended abruptly. And then this assertion that they really didn't seem to think getting help for him was important, which is the total opposite of what he says in that meeting immediately after the shooting. His exact phrase was, they were on board. That's it. So how do we go from there to portraying these parents as not caring, not knowing their son? It's just, they don't coincide, Your Honor. They are distinctly different.
Well, she wasn't going to come at first, right? She said, call the dad.
Your Honor, she's not my client.
Oh, I know she's not your client.
Mr.
But
Crumbley
you
is.
said the parents, so
I apologize.
Yeah.
But when you look at globally his statements, to be fair, I mean, he talks mostly generally, right, about mom and dad. You know, he tells him, no, they came to the school. We had this meeting. He even talks about them telling him about the grandmother passing away, about the loss of the dog, about the friend moving away, so on and so forth. So there is this exchange of information, and there's never a characterization at that time that they're somehow inappropriate.
Well, they're going to say there wasn't an exchange of information.
Well, I understand that that's what they say, except that Mr. Hopkins' interview says otherwise.
No, prosecution's going to say there wasn't an exchange of information.
In the middle of the trial, one of the things that Jennifer had going on with her horses was this mud scratching. It's a rash that the horses get around their hooves from mud. And during the trial, my horse actually had that. So in the middle of the trial, I left and went to the horse and did a live stream from that. I'm like, hey, it's something you got to take care of. I don't know what to tell you.
There was an exchange of information.
I'm neglecting my kids in my stream to go take care of the horse.
Your Honor, at that moment in time, EJAC, Hopkins, James Crumbley had no reason to believe, and this kind of dovetails into the legal duty argument, that EC was had a propensity for violent acts. Okay, under the law, and yes.
What about that picture?
Yeah.
They had the picture before they came to the meeting, right?
100%, Your Honor.
Yeah.
Your Honor, children draw pictures of things.
Listen, I'm going to back this up. Listen to the judge, the way she responds. Now, I understand. I'm going to slow this down to normal speed. Just the way she just sort of brushes off.
What about that picture?
Yeah.
They had the picture before they came to the meeting, right?
100%, Your Honor.
Yeah.
They had that picture before they came to the meeting. 100%, Your Honor. Yeah. Sorry, Judge Matthews. I can tell where you're going, and
Your Honor,
I'm not a fan of judges. All right, so this is the thing. You draft your motion, your written motion, all right? You draft it, you file it with the court. The other side files the response. Maybe you get a reply brief, and then the judge reads all of that. And the judge is sitting there after having read all of that and gone over everything with their legal staff in chambers, and they've come up with essentially sort of a draft position that they think they're going to go with. They might have some questions they note down for the attorneys, and the oral arguments are there to really facilitate the judge in making the decision. But the judge, in theory, could have already made up her mind. So I'm not saying this judge has already made up her mind and is prematurely making up her mind, because she can make a decision based off of the written pleadings alone. But it's clear to me that this judge has already made up her mind, and oral arguments are essentially not necessary in this case. And if they're not necessary, then why are we having them, Judge?
children draw pictures of things. It doesn't mean if every person who drew a picture meant that that was their intention going forward. I mean, people, I don't want to call it a doodle because I don't want to undermine the significance of it. But to suggest that because he drew a picture and has never had a history of violence that his parents knew of, specifically his father, it wasn't foreseeable. It simply wasn't. I mean, when you look at Hopkins, he saw the same picture. But what did he say? What did he tell the officer? This kid's never been in trouble. I barely know him because he's never been in trouble. He comes to school. His attendance is solid. He's never got into fights. He's never been suspended. Why is that? Because he's never doing anything wrong. You're taking a kid who has no history of behavioral problems, of misconduct in school. And
there was a phone call the day before. There was a phone call. They both were aware of the phone call the day before.
I don't know that
about
there's
researching bullets.
Right. And Your Honor,
let's talk about that phone call. That phone call was a message left by the school officials. And I don't have the video to play right now, but I have the 911 call. It might still be in my in Discord. Jung can let us know. But it was, hey, we brought Ethan down because he was researching on his phone bullets. And he told us that he just got a new gun and he was researching the type of ammunition that could be used. No big deal. He's not in trouble. You guys don't have to call us back. We just thought you should know. And that was it. That's the message. And it was very lighthearted and it wasn't even disciplinary. So why are we bringing up this phone call when the school didn't care? They were just letting the parents know, like, hey, we brought him down to the office and asked him about it and then sent him back to class.
I don't dispute that happened, but the fact that someone researches bullets, no one disputes that this was a hobby of his.
It's presented a little bit different way. And I really like the way this attorney, she'll get into it in a little bit. It's essentially the same argument, but fashioned a different way.
He enjoyed and that he did with his parents. And in some communities, that's a totally normal hobby for a 15-year-old child to have with his parents. Mm-hmm. And I think the testimony at trial very much confirms that in this community, that is nothing unusual, mm-hmm. Your Honor. But when you look at the narrative that's put forth and how it shifts, James Crumbley did not have the ability to cross-examine these witnesses about why their testimony shifted, why the information that they gave shifted. And it would have been a reasonable argument and a reasonable attack on their credibility, Your Honor, to point to the proffer agreements for the reason in that shift. But again, Your Honor, even under Davey, the prejudice prong is whether or not the defendant's ability to prepare the case has been hampered, right? And that's exactly what you have here. That meeting and their alleged conduct and disinterest in that meeting was a huge part of the prosecution's case.
Okay, so you're talking about materiality. Do you want me to let the prosecution respond, or?
It's your courtroom, Your Honor. Whatever's easiest for Your Honor.
Do you want to let the prosecution
Well, I can give you
respond?
best issue by issue. I guess I should presume that you're done talking about this part.
About the proffer?
Yeah, I
am.
Okay, well, I'm going to let them respond, and then I'll let you reply.
Thank
you.
Thank you, Judge. I think
There was a video I just saw. I clipped. Oh, hang on. Let me fix my camera.
the court, some of the court's questions, I think, correctly exemplified part of our argument, and that is the amount of evidence that was presented to the jury that is both uncontested and proved at trial that showed, irrespective of these witnesses, the guilt of the Crumbleys.
Okay, but you're jumping to the end. Mr. Keese, you agree that a prosecutor is under a duty to disclose any information that would materially affect the credibility of a witness?
Yes, Judge, Brady
If
obligation,
I had
of
a
course.
dollar for every time I said credibility is always at issue, I could retire right now,
Yes.
right? Credibility is always at issue, right? And so wasn't the defense
So there was a video that I just captured, and there was a guy talking about how men handle emotions differently than women. He's like, men, they don't like to seem emotional, so they will mask it with anger. So if you see a man that's angry, he's depressed. He might be depressed because his uh his something is being called into question, his basically his ego is being challenged and things like that. And so when men are faced with that, generally speaking, they get angry. And I was just watching that this morning, and then I just see this guy stand up. He's always angry. He's always angry.
deprived of a robust cross-examination?
No, Judge, and I do want to point out that the interview that counsel was referring to, that was turned over to defense. Defense counsel had that.
Are you,
In the
are you
first-
talking about the audio tape you sent me or exhibit 2 to your brief? What
The
interview?
interview of Mr. Hopkins from November the 30th of 2021, along with the narrative statement
Okay.
summarizing that.
Sure.
So counsel had opportunities, if counsel sought at trial, to try to cross-examine on any inconsistencies. I don't believe there to be any material inconsistencies, and I'll get to that, Judge. I do want to highlight.
No, I think what the judge was going at is I'd like to take this issue by issue. You've talked about the proffered agreements. I'd like the state to respond, and then you could talk about the Fifth Amendment issues with Ethan, and then the state can respond. I think that's really what the judge was getting at.
Few things. I want the court to recall that the evidence showed that it was approximately 1:10 p.m. on the afternoon of November the 30th, 2021, when the active shooter alert went out to parents of Oxford High School students. Those parents raced to the high school in hopes that their children were unharmed and alive. But James Crumbley didn't. He went home. He went home to look for the gun that he bought his son just 4 days before. He went home because he knew his son was the shooter. James Crumbley is the person who bought the murder weapon. He's the person who didn't lock it up, even though he was given the cable lock and an easy way to do so. James Crumbley knew his son had lost his only friend just the month prior. James Crumbley knew that his son's only hobby at this point was going to the gun range, and that his son had voiced signs of mental distress months prior. It was James Crumbley who wrote to his wife, "My God, WTF," when he was shown that math worksheet. This series of choices that I've just outlined led directly to the deaths of Hannah St. Juliana, Madison Baldwin, Tate Muir, and Justin Schilling. And those series of choices had absolutely nothing to do.
He always brings it back to emotion. This defense attorney is so good. Just listen to what her retort.
But not only that, I dispute that the crux of the testimony of Hopkins and EJAC was not uncontested, because it was uncontested. No contest, no dispute that Hopkins called the parents to the school. No dispute that math worksheet was sent to both of them. He provided a list of mental health resources to the defendants at that meeting. We know that because that's on video. He said he wanted them to get their son help that day if possible. He never testified, and he never told anybody that he had threatened to call the school resource officer or the police. It's uncontested the length of the meeting. We know that because it's on video. We know the shooter went back to class. We know that
You're pointing out things that are immaterial.
We also know that neither Hopkins nor EJAC voiced that they.
He's pointing out facts, like a timeline, like bullet points of a timeline about this happened then, and then this happened then, and then this happened then. But what does it mean? Does it mean that the parents didn't care? Does it mean that the parents knew that their son was likely to cause these deaths? No, he's skipping over that and highlighting just a timeline.
Thought at that time that the shooter was a threat to anyone else but himself. That uncontested evidence was used in part by the defendant to try to cross-examine those witnesses. This isn't testimony used to stretch or to impress the prosecution. That was just what happened. This is not evidence of somebody who is trying to curry favor with the prosecution judge. And that's important because ultimately, if the court has already made this decision on discovery violation, ultimately the decision is remedy. I don't think you should, and I would like to go through that discovery violation briefly, if I may.
Okay.
I don't, as much as I believe that our position is correct and the law is clear, I don't want to leave the court with the impression that there was an effort to hide evidence or gain an unfair advantage. I understand and appreciate the knee-jerk reaction that occurs when it's learned that a proffer agreement wasn't disclosed in discovery. I've done dozens of them. I've petitioned the court for immunity dozens of times. So I understand that knee-jerk reaction. When a co-defendant flips, they proffer, they're given a plea agreement, and they provide testimony, that always goes to the co-defendant, always. The same as someone is given immunity to testify. And the court correctly identified this. We petitioned the court for immunity to compel testimony. That's what use immunity is, Judge. And whether or not there is some sort of other name for immunity out there, that is not what was included in the proffer agreements.
Well, I think what Mr. Rowan said is they got something.
They got the opportunity to tell us what happened in the first meeting and first meeting only, with a promise that we wouldn't use what they would say to us should they be charged later on.
Well, there's an incentive there, right?
Judge, to the extent that they had any incentive to tell us what they wanted to or tell the police, that would have existed irrespective of the proffer agreement or not. They were sued in, I think, 1 week after the shooting. Multiple lawsuits, they're sued personally. That was not a secret. The civil depositions occurred post-exam, pre-trial. Trial counsel had copies of the depositions. Sean Hopkins testified 4 times. Nikki Jack testified 3 times, each without protection.
Are they testified before the proffer in the civil case?
No, civil case was post-preliminary examination, pre-jury trial.
Where were the depositions in the civil case in relation to the proffer?
Post-proffer.
Post-proffer.
Yes, proffer's 2021. I don't know the date offhand of the civil depositions.
Okay.
I do know that it occurred because we obtained the transcript, as did trial counsel. The prosecution was not a party to that. Now, I say all this because I appreciate the advocacy for a defendant as well as that knee-jerk reaction. But it is one thing during the appellate process to argue the interpretation of a court rule and quite another to assign ill intent. And I think that's important for the court to know when reviewing remedy.
Okay, but you're not telling me that it was a boo-boo, right? It was intentional. That it was, there was a
boo-boo.
willful non-disclosure.
No, Judge. I
You
would
guys
like.
decided you didn't think.
So the judge calls him out and saying, all right, so you're telling me that the non-disclosure of the proffered agreement was willful. You're not saying it was accidental. You're going to admit that it was willful.
It was a boo-boo, right? It was intentional. That it was, there was a willful non-disclosure.
No, Judge.
You
I would
guys
like.
decided you didn't think you had it turned over, right?
Thank you for bringing that question up, Judge. And I want to go.
Okay. So I wanted to, that's the Green Book is the Michigan court rules. So that's all that is. But thank you for bringing that up, Judge. Politicians speak. Can we say that this man is going to be running for office soon?
Go back to the Nikki Jack statement because I think this is a perfect example of this. At the last hearing, the co-defendant's hearing, we talked about the recorded statement of Nikki Jack. That
Answer
occurred in
the question.
2021, and when it was decided to have him testify for the prosecution
Answer
in
the
2024,
question.
we should have gone back through and identified that as a statement under the court rule. That was a mistake and was made without malice. It's not being argued here today because there's nothing exculpatory about it.
Well, I did think it was interesting that I wasn't provided with it. That means no one really cares about it, right?
Correct, because there's nothing exculpatory about it.
Oh.
Now, in the same vein, the proffer letters in 2000.
Was that an answer? Did he even answer the question? Was this intentional? Did you intentionally not disclose it because you, for whatever reason, or was it an accidental non-disclosure? I don't think he answered the question.
2021 were put in the work category box. They were not revisited in 2024. The law supports, as much as I firmly believe, and that's why we agree this is why I'm arguing this to the court, that the law supports my position that the reading of the court rule does not require that. It does not mean that these proffer agreements were shoved in the back corner of an office and decided to conceal evidence from the defendants. It wasn't turned over, Judge. That's a fact. But it would be.
Okay. It wasn't turned over. It wasn't accidentally not turned over, but it wasn't not turned over on purpose. That's what you just said, right?
Not revisited in 2024. The law supports, as much as I firmly believe, and that's why we agree this is why I'm arguing this to the court, that the law supports my position that the reading of the court rule does not require that.
So the reading of the court rule does not require disclosure.
It does not mean that these proffer agreements were shoved in the back corner of an office and decided to conceal evidence from the defendants.
But we didn't intentionally shove it into the corner to conceal the evidence. But it wasn't also accidentally not disclosed.
It wasn't turned over, Judge. That's a fact. But it would be an error to ascribe ill intent to that.
Well, it was intentional that they weren't provided. I mean, it was.
Right, but I don't want.
You guys didn't forget if they existed for sure.
I don't want to paint the picture, Judge, that we had a roundtable discussion about this to talk about whether or not to disclose the proffer agreements or not, because they were very quickly identified not to be discoverable, Judge. We went through.
This guy would prosecute somebody with the intent to commit a crime for the very act that he just admitted to doing, not turning something over, but is going to say, well, we didn't have a roundtable discussion. I guarantee that you don't need a roundtable discussion to convict somebody criminally of an intentional crime.
Items, we went through statements of witnesses. Do we need to redact this? We went through body-worn camera. What portions do we redact? What portions are relative to the case and fit the court rule? That sort of analysis didn't occur with this evidence, Judge. And I don't want my advocacy here regarding the court rule and the interpretation of the court rule to be mistaken for an admission that we tried to hide anything from the defense. So that's the point I make, because that's very different. That's an important distinction, Judge. I want the court to know that from the prosecutor's intentions throughout this case, from deciding whom to charge with what crimes, discovery process, trial preparation, and trial itself, were just. And I want to highlight something that is, I believe, a perfect example. This court recalls how we came to have separate trials to begin with. Trying this case twice was a logistical nightmare for a number of reasons, Judge, as this court knows. Our witnesses had to testify twice on international TV. Most importantly, we had to put our victims through this twice, and they had already endured 2 long years of seemingly endless litigation at that point. But it happened because—
That's all to the emotion.
It was, Judge. And the reason it occurred is because we listened to jail calls, we interviewed witnesses on Jennifer Crumbley's witness list, and we learned of Jennifer Crumbley's desire to present antagonistic defense. We reported that to counsel, as well as Your Honor, at a status conference, as I'm sure you recall. We did that to ensure the integrity of the proceedings, as well as protect the rights of the defendant.
I think that was inevitable anyway.
Either way, Judge, we didn't have to. We learned of it on our own, Judge. Trial counsel did not ask for that. Whether or not the court was going to grant it or not, I can't say. I can just relay to the court what happened to make sure the record—
We don't know.
In addition, we created waivers to make sure the defendants knew the dangers of joint representation. We created waivers when the trial counsel split to make sure they knew about how to protect prior client safeguards. We made sure, we requested that independent counsels were appointed to interview these witnesses in the jail. These defendants in the jail, so they understood the dangers of proceeding. Every time a question was asked of the co-defendant during the trial that might elicit prejudicial information, we asked the jury to be removed from the courtroom, and the defendant herself was voir dire to understand that was knowingly happening. Way back in the preliminary examination, when trial counsel was in danger of conflating the evidence as to each defendant, it was the prosecution who stood up and made a point to notify the judge and trial counsel we have separate defendants, separate pieces of evidence. Judge, again, we do this to protect the rights of the accused, and it would be wrong to ascribe ill intent to any real or perceived discovery violation. But let me talk about the court rule. So 6.21B5 says, upon request, the prosecution must provide each defendant with any plea agreement, grant of immunity, or other agreement for testimony in connection with the case. I do not agree with counsel's interpretation of the rule that for testimony does not apply to all 3 phases here, and I certainly do not agree with counsel that these proffer agreements were immunity agreements. I talked about this at the last hearing, Judge. If the court has questions regarding that, I can certainly go through it again, but I'm sure the court recalls. I adopt those arguments here today. As much as counsel or the court cannot inject a word or phrase into a court rule, at the same time, we can't make an agreement something that it's not. We met with these witnesses to prepare them for trial multiple times. The proffer agreements never came up again. Their attorneys didn't even show up for those prep meetings most of the time. That is not a situation that we commonly think of as a proffer agreement that must be turned over. So that is an important distinction, Judge. Let's talk about prejudice now. We briefed that extensively. Judge, we also briefed extensively the whole last antecedent series modifier rule. If the court has additional questions on that, I'm happy to answer, but I think counsel, as well as the prosecution, briefed that extensively. Judge, even assuming that these proffer agreements would fall under the court rule, the defendant must show actual prejudice. And that's where
there was a lot of actual prejudice.
And that is why I started off with all of these series of choices that James Crumbley made, irrespective of those 2 witnesses. Evidence is material.
This is Chanel 495-142,
Yes,
2014 Michigan Supreme Court case.
Yes. And just going back to, I described what happened with the proffer agreements and their non-disclosure. Counsel did make a point to say that I disclosed discovery 34 times and each time chose not to turn that over. That's not true. It was the first time, and it wasn't revisited. That's an important distinction. It's not splitting hairs. And again, it's something for this court to keep in mind when determining remedy. I'm sorry, I interrupted you regarding Chanel.
No, I just wanted to.
Right. I think that's a great case to review because of what happened in that case compared to what happened here, Judge. Sean Hopkins and Nikki Jack were not needed to identify the defendants. They weren't needed to, didn't have motive to put a case on somebody else. The evidence that convicted James Crumbley.
Wait. When half the population is saying, well, if the parents are guilty, why isn't the school? You're telling me that these 2 witnesses had no motivation to put somebody else in the hot seat? I mean, come on. We have the last 2 people that were with Ethan before he started shooting were those 2 witnesses, not the parents. Those 2 witnesses. And they were the ones, especially, I think it's Ejax, who testified that he did not want Ethan to go home. He wanted Ethan to stay in school because he was concerned about self-harm, not harm to others. So, yeah, I believe they were highly motivated to say, hey, we're not responsible here.
Wholly distinct from anything that Sean Hopkins or Nikki Jack were involved in.
Well, the prosecution certainly wanted them here, right? Even though it was only a 12-minute meeting, there'd be a small hole in the trial, right? If they weren't here.
Well, Judge, as a matter of trial strategy, we try to give the jury as much context as we can. It does not mean all the 20 witnesses were essential to the case. Honestly, we could have convicted the defendant with just Detective Rogowski and Lieutenant or Under Sheriff Willis's testimony, Judge, because the bulk of this evidence came
Then
through
do a new
Facebook
trial
accounts,
without
text
those
messages,
two witnesses and
video,
see how well it goes.
as well as the evidence that was sent to James and Jennifer Crumbley. We didn't even need these witnesses for a foundation for that math worksheet. The fact of the matter is, and we made
I agree with that.
thank you, Judge. We made a point about talking about this in the opening, throughout the trial and closing. Hopkins and EJAC knew this much about the shooter and about the Crumbley household. That's nothing we ran from. The counsel just argued in support of her position that he didn't know about the shooter because he wasn't in trouble. That's true, and we never tried to argue anything to the contrary. He knew this much. James Crumbley knew this, and that's the point. That's the point. It takes a rare set of circumstances to convict a parent of involuntary manslaughter for the intentional acts of their son. That's why it doesn't happen very often. It takes causation, it takes gross negligence, and it takes foreseeability, Judge. And everything else that James Crumbley knew, that's what convicted him. There just weren't very many factual disputes in the trial. That's the crux of prejudice and materiality. I'm with the court.
What do you think about Taylor and Davey though?
Davey is cited by Dickinson, Judge, in support. It's cited by Dickinson. And the crux of Taylor is that the objecting party should not be put in a better position. This would put James Crumbley in a better position. Dickinson's test of outcome determinative prejudice is the guide for this court. And that is why it is the same test for materiality, Judge. Evidence is material if it creates a reasonable probability of a different outcome. That's the standard. What is material is all of the evidence uncontested that James Crumbley knew about his son, all the evidence that was proved by a number of different witnesses, not named Hopkins and EJAC, proved by forensic downloads and cell phone towers, GPS data, that proved that James Crumbley was grossly negligent, that proved that he was both approximate and factual cause of death, and that this was foreseeable to him. We did sort of get into the argument on the Fifth Amendment aspect of it. I'm sorry, not Fifth Amendment, regarding the duty. Thank you. If the court would like me
You want me
to.
to let her respond to you and then we'll talk about duty?
Yes.
I issued a ruling already on inconsistent theories and duty and unanimity, right? So,
Not in this case, Your Honor.
but not with regard to this case, but there's plenty of overlap. So I know I'm just stressing that so that you put the highlights, and I know there's some things in your brief that were not in the brief presented on behalf of Mrs. Crumbley, but yeah. So can she reply to you? Or?
It's whatever the court would like, Judge. And there's just one other thing that the counsel mentioned that I neglected to bring up earlier. Only four people in the world knew about these proffers. That's not true. I mean, Hopkins and EJAC both had their attorneys. We never asked for an NDA. We never told anybody to keep it quiet. I have interviewed gang member witnesses before where their safety would be in danger if things got out, if they didn't testify. That's not the case here, Judge. And I keep bringing this up.
I'm going to be talking about
just because I think I want the court to contextualize what actually happened. I just want the court to be aware of that. The only aspect on duty I want to bring up is that essential part of duty is foreseeability, which was instructed to the jury. That was part of the jury instruction. So that's all on that part. Thank you.
Thank you. A couple things. It's always difficult because I can never read my own handwriting. But when Mr. Key stands before Your Honor and says that these proffer agreements were identified as not discoverable, frankly, Your Honor, that's terrifying. It's terrifying to think about potentially how many other cases they haven't disclosed similar agreements. It's terrifying that a prosecution team with 83 years of experience doesn't know that they have to disclose this under Brady. My reaction is not a knee-jerk reaction. It's a reaction that is born out of the Constitution, out of defendant's right to due process and to present a defense and to cross-examine the witnesses against him. So if our Constitution wants to be called a knee-jerk reaction, then that's fine. But my reaction, and I think the reaction of a lot of people, Your Honor, stems from constitutional guarantees that a criminal defendant has. And I'll knee-jerk react to that all day, Your Honor. Your Honor, he made a comment and sort of went through this litany of events that speak to the virtue of the prosecutor's office, that because they did the right thing in one instance, it means that there was no bad intent here. Your Honor, I'll tell you what the difference is. The difference is those instances that Mark Keese talked about were instances that were on the record in open court, not in a closed room at the prosecutor's office where they could shove a proffer agreement into a drawer and not revisit it for 2 years before this case moves to trial.
No, I don't think he's talking about instances that were on the record. We had a combined pretrial conference in a jury room, and that's when the prosecutor raised that there were jail calls from Mrs. Crumbley basically indicated she was going to flip on her husband. So,
Right, but that's known to the defendant.
It
It's
was-
no,
it
no,
was
it
known
is
because-
known to a defendant. Jennifer Crumbley knows that she's planning on flipping.
yeah,
Her,
Mr. Crumbley didn't know that.
I understand that, but she knows, her attorney knows, it's not something that's clandestine. It's not something that the parties aren't aware of.
Mr. Crumbley and his attorney didn't know.
I understand that, but Your Honor, if one defendant knows about it and that defense counsel knows about it, quite frankly, I'm not sure why the prosecutor's patting itself on the back, because defense counsel would have had an obligation to disclose it anyway. So it's not as if they were, well, I'll just leave it at that, Your Honor. Again, I want to stress the distinction between discovery violation and Brady violation. The tests are different. The tests for materiality are different. The discovery violation, Your Honor, is the stronger argument for Mr. Crumbley. I believe he wins under both, but with the discovery violation, that outcome determinative language is not required to impose the sanction. And I 100% agree with Mr. Keys that the case law says, right, that the sanction or the remedy should not be a windfall to the defendant. 100%. The defendant should not be in a better position after the remedy. But to argue that Mr. Crumbley would be in a better position, I think that's illogical. That's illogical. If you grant a new trial, you are putting him in the position that he should have been in when his trial started. He should have known about the proffer agreements. His attorney should have been able to cross-examine Hopkins and EJAC about their bias and motive stemming from the proffer agreements. So I really struggle to understand how he would be in a better position. He would have his day in court that he should have had when he first went to trial.
I think that judge likes Jennifer attorney better. No, I think the issue was raised for the first time with Jennifer's attorney. Now that James' attorney is raising the same issue, she's already rehashed it. As the judge said a moment ago, she's already made rulings on many of the motion grounds, or many of the motions that were asked for on various grounds. And I think the judge is giving this attorney, James's attorney, the opportunity for oral arguments, but has already heard them all before. I think that's why the judge's appearance in these two different cases are different.
I don't know. I guess one of the problems with that in Mr. Crumbley's case is, regardless of whether Mr. EJAC or Mr. Hopkins testified or not, I mean, Mr. Hopkins wasn't going to say, it was me, I was the straw man who purchased that gun and gave it to the shooter.
Sure.
I mean, right?
And I was just going to reply to that, Your Honor. So the prosecution keeps saying that there's this tremendous amount of evidence that's uncontested and uncontradicted. And I really think there has to be a qualified statement to that and context to that statement, because it was uncontested because EC didn't testify. It was uncontested because his medical records couldn't come in at trial. Because if there's one thing my brief makes clear with citations to the CFP report, is that this child told the Center for Forensic Psychiatry that he never told his parents he needed help, specifically his father, that when he was feeling suicidal, he did not tell his parents. He put on a happy mask.
So how could he know?
So when you
How
look
could
to CFP,
how could James
there
know?
is plenty to contradict the prosecution's theory. It just wasn't allowed in at James's trial.
Okay, well, there's good reason for that, right? It's hard.
I would respectfully disagree.
Well, I guess that would be for the Court of Appeals of the Supreme Court.
Agreed.
I guess I would say to you that we thought long and hard, researched. Everybody involved in the trial spent a lot of time, and there is no allowance at all for those records not to be privileged. Those records.
What they're talking about is the psychological evaluations of Ethan, where Ethan says that his parents didn't know any of this. And of course, his parents would want them in. The court suppressed it, saying that it is confidential and they're not allowed to get it. And then we go into the whole issue of text messages versus allowing Ethan to testify. And then he asserted his Fifth Amendment. We get into that in a little bit, but that's what we're talking about here. Basically, there's a ton of evidence out there that Ethan stated that he never told his parents didn't know, and that none of that was allowed to come in.
Privileged. I don't know what to say. Can I say that some of it is unfair? Maybe, but I think you're supposed to get a tape next week of the hearing we had under seal. But to be honest with you, I think you're going to figure out that when you get that sealed record, it's anticlimactic.
Your Honor, so the sealed record, of course, is from Jennifer's trial, not
Right.
There was no separate
Right,
sealed
but
record.
it's a reference. It talks about references to mental crisis by the shooter.
Your Honor, I don't.
We're getting in the weeds, right?
Yes, Your Honor.
I guess I understand your concern about not having the records from the Center for Forensic Psychiatry, but both sides, all three sides in this matter, researched, looked at the law, So did I, for many, many hours and many evenings and many times when I should have been sleeping. And there is a feeling of unfairness potentially about that. But there's no question in my mind that those records are privileged, and the privilege is held only by the shooter. So I don't know that there's a way around that.
And I know that this isn't an issue before the court, but certainly there is authority that privileges must bend to a defendant's right to present a defense, his constitutional right to present a defense.
I've seen those cases, yeah.
And because those records didn't come in, Your Honor, the jury is presented with text messages, right? Not even direct testimony from EC that he allegedly told his parents that he was suffering mentally. And you have a complete 180 when he's interviewed at the CFP, a complete 180.
I'm not positive that the prosecutor wouldn't also like those records to come in. Sure.
Oh, Your Honor, the records are relevant. First of all, the records in their entirety are not relevant, right? Because there's a lot in that report that deals with information that James Crumbley knew nothing about. And that's never been contested, right? Certain disturbing actions by EC, right? There's no evidence that James Crumbley never ever knew about those activities. So that would be completely irrelevant in a trial against him, and it would be highly prejudicial. But what is incredibly relevant, okay, and what prejudiced his defense was that the jurors were never told that EC repeatedly told the CFP that he did not tell his parents he was struggling. He did not tell them he was suicidal. And he specifically explained that he didn't do it because he didn't want his parents to think he was not normal, or he didn't want to make them worry. So, Your Honor, that is incredibly exculpatory for Mr. Crumbley. So what I don't like is this suggestion that there is uncontested evidence. It's uncontested because the evidence wasn't allowed in, not because it doesn't exist, Your Honor.
We're talking about the fact that he bought his 15-year-old son a gun, left it laying around unsecured, and
That's not
presented with that picture.
that's not what
Yeah.
Ethan says.
So, Your Honor, and now we're kind of getting into the duty. So can I kind of
Sure. Well, I know you responded to Mr. Keese, but yeah, so you want to talk, I'm going to let you make a record about duty. For sure. Okay.
Your Honor, so first of all, I would say that additionally, EC, reported that the gun was hidden from him. He went into his parents' room knowing that they were sleeping and removed that gun at a time when he knew that they would be sleeping and that they had hidden it from him.
They did a bad job.
Not all parenting is perfect, Your Honor. They kept it from him, and
They did a bad job. Now, in response to Ethan saying the gun was hidden from him and he went in and took it from his parents without their knowledge while they were sleeping, the judge says, well, they did a bad job. So now, a parent making a mistake could cause them 15 years in prison.
moved that gun at a time when he knew that they would be sleeping and that they had hidden it from him.
They did a bad job.
Not all parenting is perfect, Your Honor.
They did a bad job. So the judge is acknowledging, for the sake of argument, ideally, that Ethan's statements are true, and that's exactly what happened. That the parents took the gun from him, hid it, and he snuck in while they were sleeping and stole it from them. Well, they did a bad job.
Kept it from him, and they were not legally obligated to lock it at that time. Your Honor, as it relates to the duty issue. So it's undisputed. I don't think the prosecution contests this, that there was no evidence at trial that James Crumbley knew of any prior intentional tortious acts by EC. There is no evidence of that. Without this knowledge, Your Honor, he cannot have a duty. There is no legal duty, and there is no ambiguity in the case law. In its brief, the prosecution cites from the Muma case, which is a case that I cite, and they cite the following language. Since the law, as stated above, stresses foreseeability as a prerequisite to a finding of actionable negligence in cases of lack of parental supervision, and we find no such foreseeability here, we hereby affirm the lower court's judgment. That's the quote in the prosecution's brief. But if the court looks to just the preceding paragraph, right, you would see that also in the Muma court, it talks about the child in the Muma case, right? He takes his parents' car and he gets into an accident and inflicts injuries. And the court says that the child did drive the car the day before the accident, but this was after his parents had left for the weekend. Therefore, the defendant parents could not have anticipated or foreseen that their son would take the car while they were away, since he had never done so before. Foreseeability, Your Honor, is born out of a parent's prior knowledge of prior tortious intentional acts. That is what makes that child's acts foreseeable and what gives rise to the legal duty. There is no evidence of that in this case. What also strikes me, Your Honor, is that the prosecution asserts in its brief that the cases on which I rely do not include this requirement. And frankly, it's as if they didn't read any of the cases cited in the brief. Your Honor mentioned...
Which she's going to go into is such a pet peeve of mine.
Well,
I get it a lot.
Comment on the length of the brief, which is fine. I mean, it was long, but it's long because 51. That's even longer than the Court of Appeals accepts at this point. But the cases, Your Honor, that are cited, I don't just give the court the name of a case. I explain the facts, the holding, why it applies. And what's amazing is that they make a blanket assertion that none of those cases stand for the proposition that I use them for, and give you no analysis of how those cases are wrong or how they don't say what I say they say by way of copious.
Hey, Stacy NAT. Well, welcome. So Ethan Crumbley, the child, was 16 at the time. And so the background is this. In November 2021, Ethan Crumbley is given a gun. His parents purchase a gun for him. They take him to the range. They're trying to find him a hobby. And one of the hobbies that he seems interested in is shooting. So they get a gun. He goes shooting once or twice. I can't remember how many times. And the parents hide it from him. Apparently, Ethan steals it in the middle of the night while the parents are sleeping, takes it to school. The parents are called into school for some troubling images that Ethan is drawing. The school ends up keeping the child because they believe the child is in danger of self-harm, and the parents are given resources to contact therapists and things like that, and told by the school within 24 hours they want to see him set up for some sort of mental health evaluation, or at least an intake with a counselor. So the parents then leave, and then Ethan goes into the bathroom, removes the gun from his backpack, which, by the way, the school doesn't search the backpack, even though they have all these concerns. And he shoots and kills 4 students, injures some teachers and other people. And the parents have been charged and convicted of involuntary manslaughter for failing, essentially, to parent their kid properly. And this is a motion for the fathers, on the father's case, to set aside his conviction and for a new trial, because in part, the prosecution withheld a proffer agreement to the 2 school officials that testified that were really key here, and that was the assistant principal and the school counselor that met with the parents and the student, and were the last people to be with the student before he started shooting. The proffer agreement says basically, if you testify favorably towards us, then anything you testify to, we won't use in any potential, maybe criminal conviction against you. That information, the fact that there was this agreement, was never disclosed to the defense. There's also another issue, which is that Ethan, the 16-year-old, apparently had thoughts about this, but said his parents didn't know. Said that he stole the gun, and his parents didn't know. That he never expressed any of these mental health issues to his parents. His parents didn't know. And the crux of the prosecution is that the parents did know, and they did nothing about it. However, Ethan wasn't allowed to testify. Text messages of Ethan to Ethan's friend, with no evidence that the parents ever saw that, were introduced without the ability to cross-examine Ethan. Ethan's mental health records were not allowed to be brought in. And so there are a lot of things that weren't allowed in at the parents' trials. And so that's what we're dealing with now. And hopefully that all made sense. And welcome.
Direct quotes from the case. So if you remember, they criticized defense counsel in their brief, not me, trial counsel, about abandoning an issue, right? Because you can't just make a claim and then completely fail to develop it. That's
yeah,
exactly
the friend
what
wasn't testified
either.
either.
Argument, Your Honor. They just want to say to Your Honor, hey, Judge Matthews, what she says the cases say, they don't really say that. Okay, now let's move on. Let's not engage in any meaningful analysis to persuade Your Honor of that point. The case law is the case law. Prior knowledge by a parent is what gives rise to the legal duty. There is no evidence of that here.
Don't you think that the Court of Appeals sort of touched on this?
I do think that they did. And frankly,
yeah, the Court of Appeals, by the way, there was an interlocutory appeal, and that's an appeal before the trial. And so the Court of Appeals said that if the state can prove that the parents knew that the child had a propensity to commit this sort of act, and then also failed to take steps to protect the school from their child, if they can prove that, then maybe there's a cause of action. But it was very narrowly tailored, and that's not exactly what they said. I'm paraphrasing it, and it was much more narrowly tailored than what I even said.
I don't,
You talk about
I'm
this
trying
being
to
an
be-
extremely unique set of circumstances.
Your Honor,
You
different.
don't want to call out Court of Appeals on the record.
Oh, no, that's fine. I think my reputation there is good enough. But
Yeah.
different
Oh, yeah.
lawyers
Yeah. He was
will
very
raise
educated in
issues
things.
in different ways. Sometimes lawyering from one lawyer may be more persuasive than the next. I wasn't there. I didn't read the briefs. You know, that's not really.
Yes. There's been another parent charged in the death of a toddler. And then I got a new case, not a new case, a case that I've been talking about a little bit. It's an ancillary case because it's a hypothetical that we raised during the trial. And I'll go over it at the end of this hearing. We have maybe another 20 minutes left of this hearing. And then I'm going to go over a different case here out of Michigan that is piggybacking off of this. And basically the fear that we all thought was coming, it looks like it might be coming. But for one very brave, determined, and good prosecutor, charges weren't brought.
Necessary for my representation here. But what I can say is where there is no prior knowledge, there cannot be a duty. And if you look, a case that came out after Crumbley, it's People versus Aish. It's AIYASH, came out maybe even the last 8 to 12 months. It's that horrible case in Detroit where the clerk locked the people in the store and they got into a fight, and then one guy who's locked in there shoots and injures and I think kills one of the other people in the store. Your Honor, you know, one of the reasons why the clerk there wasn't held responsible was because he didn't know this person. He didn't know any prior instances of violence. And that is the same here. That is absolutely the same here. The prosecution has never argued that James knew EC was violent, that EC was ever violent before. And we know from Hopkins, he was not a kid that got into trouble. He didn't get into fights at school. He didn't get into fights in the neighborhood. Nothing. There is no evidence.
Why did he have to know that there was some prior instances of violence?
Because that's what the case law requires.
Didn't he just have to know things about him, like all the things that were happening in his life, including the friend, the fact that there was an unsecured gun at his house. He
To suggest
had
that,
access to his Instagram.
Your Honor,
account.
just first of all, just because someone has access to Instagram doesn't mean they're constantly trolling it. But to answer your question, Your Honor, if you followed Your Honor's,
this kid had silhouettes all over his room, right?
it was a hobby that he did with his mother. That's not okay. Shooting a gun is not in itself violent. If you're going to the range, I mean, that's essentially saying that anyone who goes to a gun range as a hobby or to practice is violent.
No, of course not. But he knew that his son was and then there was the phone call the day before about him looking up. He was so
There was a ruling early on in this case because he was a minor at the time that they weren't going to use his name and they would only use EC. That's been consistent throughout. Even though Ethan was charged as an adult and sentenced as an adult, they still use EC because he was technically a minor at the time.
he had to be at school while he was at school looking at bullets and things like that. Like it's not just one thing.
No, but the law requires, and I'm sorry, I didn't mean to interrupt.
Go ahead.
But the law requires knowledge of prior intentional tortious acts. Otherwise, there cannot be foreseeability. That's what the case law. I mean, Your Honor, you have cases that I cited where the parents had some knowledge that the children were engaging in sort of somewhat nefarious conduct, but because there hadn't been explicit acts of violence, then the parents don't know about the propensity of that child. You have a child here who engages in a hobby with his parents as a way of spending time together. That is not an act of violence, okay? And to suggest that just,
100% agree.
Just because he may have been struggling and feeling sad, which is what Hopkins described him as, right? He just seemed sad. To suggest that somehow gives foreseeability of someone committing a mass shooting, okay? In today's climate, 80% of us are probably sad the majority of the time. That doesn't mean we're going to go commit a mass shooting, and it certainly doesn't make it foreseeable. The standard is prior knowledge of prior intentional tortious acts. Without that, Your Honor, there is no legal duty for the parent to act. Your Honor, that is my argument as to the duty part. That concludes the duty portion of the program. Does Your Honor want to give Mr. Keese an opportunity? I don't know.
Would you like to respond
Sure.
to the argument?
Just briefly. this has been before this court before, so I'm not going to belabor the point. I believe the court is correct. The Court of Appeals did touch upon this as well as the court.
I should say that I'm definitely interested in and required just to consider each defendant individually.
Of course. Thank you for making that the record, Judge. And that's absolutely true. I bring that up only because the issues are so similar, and I believe the court can draw from that. It is, again, a unique set of circumstances, and the Court of Appeals made this point, as did we in the Court of Appeals, and to the jury. A unique set of circumstances where a parent could be held responsible for the acts of a teenage son. Foreseeability is key. I agree. Foreseeability is an essential part of this, Judge, and that was argued to the jury. That's a jury question. Those are the aspects that put forth the jury, and the jury made that determination. There are multiple ways. So Alvin states clearly that the law in Michigan is that a parent is under a duty to exercise reasonable care so as to control his minor children as to prevent them from intentionally harming others.
Yeah, maybe he was
from
15
so conducting themselves to create an unreasonable risk of bodily harm if that parent knows that he or she has the ability to control his children, and two, knows the necessity and opportunity for exercising such control. Of course, should James Crumbley have been made aware that his son was shooting at people in the past or engaging in some other sort of violent tortious acts, that would be evidence of foreseeability, but it's not required. It's just simply not required. So regarding the duty aspect of counsel's argument, I'm asking the court just to refer back to the first motion to quash that we had. That was what was appealed to the Court of Appeals, in the Court of Appeals opinion. I believe it's clear in that aspect. I do want to go back and make one quick point. When counsel talked about the forensic report, as this court sort of alluded to, and counsel's a bit of a disadvantage because she wasn't here for that argument and it's still sealed, but the court did find.
I'm predicting I will have a Court of Appeals live oral argument stream in about 12 months, Chris. That's my prediction. And I believe the Court of Appeals will aggregate. I don't know if they'll aggregate the cases, right? So both parents were tried separately. They were tried together until the last minute, and then they separated out the cases. And both are going up to the Court of Appeals separately. And the Court of Appeals might aggregate them, or we might have two oral argument trial streams. But I imagine it's going to be about 12 months from now.
That's fine, Judge. And the point I want to make is just so the record is clear that the court did find that there was nothing exculpatory in that. In the court,
yes, Ethan is appealing his sentencing.
Portion of the Forensic Center report that was specifically requested, and we had the closed hearing.
That's correct, Judge. That's correct. And also, Judge, there's no criticism of trial counsel in not pursuing this issue. She removed the shooter from her witness list, probably for good reason, because it doesn't stop with just questions defense counsel asks. We have a whole lot of questions they ask too. And there are a lot of information.
Are we going somewhere else now?
No, I was just responding to counsel's argument regarding the forensic report. Yes.
Yeah.
Thank you, Judge.
And yes, I am streaming from a
I'm not going
treehouse.
to address the duty issue anymore. I think I think it's been well covered. The last issue I intended to address was the Fifth Amendment issue. I do just want to just briefly say a little bit ago, Your Honor mentioned that you had.
So right before the trial, and they might get into this a little bit, but just for some background, right before Jennifer trial started, Jennifer went first, and that was in February of last year. Ethan Crumbley, through his appellate attorneys, he had already pled guilty, and they had the Miller hearing, I believe. And the Miller hearing is for the sentencing of a juvenile when they want to try to sentence him to life. I believe they had that by the time the trial started. But anyways, through Ethan's appellate attorneys, they filed a notice that Ethan will plead the Fifth Amendment. Now in Michigan, much like other states, you can't put a witness on the stand in front of the jury if you know they're going to plead the Fifth, because the courts say that taints the jury. Well, if they see a witness on the stand saying, I plead the Fifth to a bunch of answers, then it skews their perspective of the case or something. I don't really agree with it, but that's the argument. So Jennifer's attorney was not able to call Ethan to the stand. The judge had excluded him because of this. Essentially, it was more like an oral email or something, or oral statement or an email statement. It wasn't like an official letter or filing in the court or anything saying that Ethan's going to plead the Fifth. That was Jennifer's case. And then in March, James's case started, and the same thing was of issue. And so the question is whether or not this Fifth Amendment was properly noticed in James's case. All right, so that's what we're talking about.
Had already previously ruled in Jennifer Crumbley's case on some of the legal claims that I think on their face or on the surface kind of overlap. But I do just want to stress to the court that as it relates to the inconsistent theories, There is no overlap between Mr. and Mrs. Crumbley's arguments. They are extremely distinct. They rely on different law. Well, the law is similar.
Well, you told me this in a pre-trial, and that is specifically why I did not rule on everything with regard to Mrs. Crumbley, because you did persuade me that it wouldn't be fair to not read your brief and listen to your argument. So.
Thank you, Your Honor. So I just wanted to point out, especially when it comes to that issue.
I don't know. I would like it to be,
Your
but
Honor, as it relates to the Fifth Amendment,
it's not going to be a thing that's it's like this entire case is not turning on whether or not a witness a defense should be allowed to call a witness even if they're going to plead the Fifth. Although it could be something that's briefed out and it could result in a change to the law. But I don't see this case as being the one to challenge that. This case has a lot of other issues that need challenging. And this one isn't really, it doesn't have the right facts just enough. Essentially, what you would need is a case where the witness did state the Fifth in front of the jury. And for whatever reason, that case went to the Court of Appeals or the Michigan Supreme Court. That, I think, would be the case that would change it.
I don't have a ton to say here. I do just want to point out that the prosecution's argument in its brief really doesn't make sense from a chronological standpoint, because they criticized trial counsel for not filing a motion back in 21 or 22 about EC testifying.
No, I think what happened is that we were all here, and Ms. Smith said, in Mrs. Crumbley's case, this is when they were together, Mr. and Mrs.
Yes, Your Honor.
So she said something to the effect of, "I'm going to need the shooter as a witness," and knee-jerk, I said, you can't take a Fifth in front of the jury. So
of course,
you got to send up a flare if you think that's going to happen, because he can't take a Fifth in front of the jury. So I pointed that out and I encouraged a motion on that issue. And at that time, both of the defendants were together. So Ms. Smith was here and Ms. Lehman was here. So I think that's what the process.
Yeah, and there's two different things we're talking about here. Is that so? Ethan's journal was allowed in, as well as Ethan's text messages. Yet by the state, and yet the defense was not allowed to call Ethan to the stand. So more to the point of, a more appropriate argument for the Court of Appeals would be under the Confrontation Clause, right? Under the Confrontation Clause in both the state of Michigan and the U.S. Constitution, you have the right to confront and cross-examine any witnesses against you. So by admitting Ethan's journals, by the court allowing Ethan's journals and text messages to come in, but then not allowing the defense to cross-examine those by calling the author of those journals and text messages to the stand and cross-examining them, does it violate James and Jennifer's Confrontation Clause? That's a bigger issue than the Fifth Amendment issue. And so this is not the right case to really challenge the Fifth Amendment issue like we've been discussing. It's really a Confrontation Clause issue.
Here, that's back when they were together, and I was sort of surprised to hear that, because that would be a whole thing, right?
Surprised to hear what, Your Honor?
That she said that Ms. Smith said she wanted to call the shooter, and then later made it sound like I was required to compel the shooter to testify, right? So that.
Okay, so I
said, bring this needs to be, if you think that you can bring the shooter in and I can compel the shooter to testify, and this was directed to Ms. Smith, you better file a motion, because that is not how I read the law. And so the prosecutor's point is that
Jung, you have a dirty mind. You have a filthy, dirty mind.
Ms. Lehman was there. So anything brought in this case caused a little tidal wave, and everybody to start scurrying around and researching and setting dates for pre-trials and hearings and all that. So everybody in the case knew if there's an issue, you need to tell us what it is.
So Your Honor, to respond to that, my point is that in 21 or 20, so that hearing happens, I believe it's June 27th of 22. Mr. Keith, if I'm wrong, feel free to. Okay. Is that at that point in time, there had been no invocation. No one on behalf of EC, and EC himself, had not invoked his Fifth Amendment right against self-incrimination. What had happened at those
Correct.
time periods, thank you.
At that moment.
Correct. So there was nothing ripe to bring before Your Honor in terms of filing a motion to compel testimony, because he hadn't invoked. The very first invocation happens, I think it's one day prior to Jennifer Crumbley's case, which is January of 2024. So
I think there was a feeling of shock when she said that, because I think everyone at that time truly believed that calling the shooter as a witness would be tantamount to dropping a bomb in the middle of the courtroom.
Well, Your Honor, and Okay, I don't disagree because Your Honor is entirely correct that you can't put a witness on the stand knowing that they're going to invoke. But no one knew whether or not he would invoke. That's number one, because he hadn't invoked. And then once he does invoke, respectfully, Your Honor, that imposes certain obligations on Your Honor. The case law is clear that when an attorney or a defendant makes a blanket invocation of the right against self-incrimination, there must be inquiry, right? The court respectfully is not free to simply accept that blanket assertion. So when does that assertion happen? Late January 2024, like a day before. Well, it kind of starts the day before Jennifer's trial. Then it's solidified, I believe, the first day of trial.
Well, the state court defender's office sent a letter and then sent an email.
Right, but the letter respectfully wasn't a valid invocation because in that letter, she concedes that she had not met EC yet.
But the next day.
Correct, 100%, Your Honor. But once that happens, right, what had to happen under the case law is that EC had to be brought here for a hearing outside of the jury. 100% nothing could have happened in front of the jury. But the court is required to make a finding that the invocation is valid and that he understands it. Your Honor, given the facts in this case, I think it is, I don't want to say highly likely, but a distinct possibility that EC would have testified in his parents' trial.
The prosecution would have loved that.
I don't know that, because then all of his statements to the CFP, Your Honor, about never telling his parents that he was struggling that is the center of their case. These text messages to friend B that he is having hallucinations, which by the way, the prosecutor's own expert says he never had. Okay. I mean, that goes to the inconsistent theory.
She questioned.
She said, Your Honor, very clearly that people don't share hallucinations. And every time he talked about hallucinating with the doctor, the expert at the CFP, he talked about sharing that his friends saw the same hallucination he was seeing, which led Dr. Anaker to give the opinion that he was not experiencing hallucinations.
Okay, so you're saying I didn't correctly handle the Fifth Amendment issue because I didn't bring the shooter here in his bulletproof vest and put him on the stand and ask him if he was going to take the Fifth.
So dramatic, Judge.
So you say the Fifth Amendment was not invoked, but I think it was invoked over and over again by his counsel.
No, it was invoked. I don't dispute that it was invoked. I dispute that in 21 or 22 that it was invoked, which should have led counsel to file some type of motion. It wouldn't have been ripe at that point because nothing had been invoked, and I think Your Honor agrees with that. But once he invokes, Your Honor is required under the case law to make a finding if the invocation is valid and to make sure that he understands the invocation. And that didn't happen here. And yes, I do argue that he did not have a valid assertion under the Fifth Amendment because counsel could have asked questions, Your Honor, narrowly tailored his questions, her questions.
Judge seems unpersuaded.
What question would not be covered by the Miller hearing, the fact that the Miller hearing and the resulting sentence was being appealed.
You were impressed by Jennifer's arguments
when Mrs. Smith said she was interested in.
You mean the motion arguments with the Court of Appellate Attorney? I thought you were talking about Shannon, the trial attorney.
I can't imagine a way to call the shooter.
Because if the questions asked of EC are confined to information that is already known by the prosecution and by the sentencing judge, how can there be additional incrimination?
I don't know. I can't imagine a question he could have been asked.
Your Honor, I go through a list of 17 of them in the brief.
Did you go on a camping trip? I don't think that he could have answered any of those questions. A lot of those questions are from a Miller hearing because his background.
No. That information is lifted from the CFP report. That's why I specifically tailored it to that.
That's separate, though. That's separate. Just because he answered
a
questions.
good judge would be willing to self-reflect, though.
Be compelled to testify under oath.
Your Honor,
questions, but they would also be the subject of a Miller hearing, right?
They were already the subject of a Miller hearing. They were already 100%. Those facts were already known to Judge Rowe. The CFP report was made an exhibit at the Miller hearing, which means the prosecution and Judge Rowe were already made aware of all those 17 facts that I list in the brief that are all helpful to James Crumbley because he is portrayed as some disinterested, negligent father. And the fact is that EC statements at the CFP do not support that. They don't support that.
I know that's your position, but try as I might, I couldn't do anything about that.
All right, well, welcome, Little Red.
But it was required that Your Honor make that inquiry. Counsel does not have to ask for it.
I didn't bring the shooter in and ask him. I didn't.
And Your Honor, the only way to remedy that is with an evidentiary hearing.
Okay, so you want me to bring the shooter in and ask him?
I want the court to make sure that it was a valid invocation and that it was appropriate. That's how you correct the mistake.
I guess I would have to say that I'm satisfied that he invoked his Fifth Amendment rights.
That's not the question.
Okay.
The question is whether or not the blanket assertion.
Yeah, I have a whole playlist. So there's a Jennifer playlist, there's a James Crumbley playlist, and then there's an Ethan playlist. So if you want to go check it out, we have all of that in my channel. But the reason why is because Ethan, the shooter, pled the Fifth. He said, "I'm not going to testify to anything under the Fifth Amendment, the right to remain silent." And so Michigan has a rule that if you know a witness is going to plead the Fifth, you cannot put them on the stand because it'll prejudice the jury in some way.
Appropriate.
So the question is did he actually plead the Fifth?
Your Honor, that's all I have to say on the Fifth Amendment issue. I did just have one other, and I don't know if Mr. Keese wants to respond. I did have one other sort of point that I wanted to make to the court that kind of culminates everything, but I can certainly wait, or Your Honor can just tell me to sit
I'll
down.
respond. And
Thank you, Judge.
One or both of you might not be happy with my ruling, but you won't say that. Let you say everything you wanted to say.
Thank you, Judge. I'll be brief because I believe the court recalls the June 27, 22 hearing. And I do want to point out that we do assert that Ms. Lehman abandoned the issue, but that's not critique or criticism. That's just appropriate to point out for the appellate posture of the case, Judge. And she abandoned it likely for good reason, as the court has already indicated and read that friends. Now, the fact of the matter is that the shooter's own expert at the Miller hearing called him a feral child. If that information were all to come out, Judge, like you said, we tantamount to dropping a bomb in the middle of the courtroom. Judge, the fact of the matter is that the information that would come from the shooter, every question would be an issue for him. There's an opinion yesterday from the Michigan Supreme Court regarding juvenile lifers, Judge. This is an ongoing issue. We're in the middle of the appeals right now. He asked for a new trial or to withdraw his plea already. That was denied. That's on appeal currently, Judge. Anything that would have been asked by either party would be an issue for him in the Miller hearing. I think the court is understanding that. So if the court has any other questions, I'd be happy to answer. But I do just want to refer for the record back to the court's
I'll redirect
soon-to-be
you
unsealed record
Al.
regarding the forensic report and its non-exculpatory nature, and the fact that,
Are you not a
again, we never stood up and said privilege. We just said, as the court correctly pointed out, he does have a privilege, and all parties research that issue. Thank you.
Well, I did a lot of research about that because
I don't know why you don't have a wrench,
obviously
but you
things
do
that
now,
you said,
Salvador.
the shooter said would be of interest.
Go ahead and drop your
and,
link.
Relevant to both Mr. and Mrs. in their hearing, in their trial. But there's no support for the release of it. I looked for it because there's just no support for it. It's the privileges belongs to the shooter and no one else. So, what else would you want to say?
I just wanted to kind of close it. I do want to address one statement made
Go
by
ahead, go
Mr.
ahead.
Keith.
I'm gonna let you both say whatever you want.
Thank you, Your Honor. You've been extremely patient this morning. Mr. Keith mentions that that EC's own expert referred to him as a feral child.
Oh,
The prosecution's own expert said that EC was not mentally ill, that he was hopeful at the times preceding the shooting, that he was engaged in hobbies that he found enjoyable. So to the extent that you want to start putting out there what different experts said, it's the prosecution's expert who portrayed EC at his Miller hearing as hopeful and engaged and spending time with his parents and generally had a very good childhood without negligence and abuse. Those are, Your Honor, direct quotes. They are in the brief, and I've attached her testimony from the Miller hearing. So I am not playing fast and loose with the facts, Your Honor. Your Honor, I wanted to just sum up. Every time, Your Honor, that I've seen this topic of the prosecution's misconduct is discussed, whether it was when Jennifer Crumbley's motion for new trial was being arguing, whether it's in the press, the prosecution pivots. It pivots from the attention on its misconduct
Oh, I love this part.
to the absolutely horrific murders that happened in this case, rather than focusing
Preach.
or even acknowledging their own misconduct.
Sing it,
And Your
girl.
Honor, it is, in my opinion, a very blatant attempt to distract the court and the public from how they failed to give James Crumbley a fair trial.
100%.
How their misconduct robbed him of meaningful cross-examination and a chance to expose to the jury the biases of Hopkins and EJAC. This case, Your Honor, is gut-wrenching. It is heartbreaking, and it is traumatic for an entire community. But our rules and the court's obligation to ensure due process and a fair trial and full and fair cross-examination cannot bend to emotion, Your Honor. If it does, then our justice system has no integrity, and the rules mean nothing, and the Constitution means nothing. The parties must adhere to the rules, and you must enforce them equally to sympathetic defendants and to defendants who garner the most visceral of reactions, Your Honor. In this room, the law must reign supreme regardless of pain and trauma. And I can just see the headlines now, Your Honor. Callous defense counsel doesn't care about the pain of the families in Oxford. And that is not true. Your Honor, and it's funny, it's ironic because Mr. Keese just mentioned, the movement in juvenile lifer cases. When Miller was decided in 2012 and made retroactive in 2016, our courts repeatedly acknowledged how painful this change in the law was going to be for families, right? Families of victims who for decades had maybe reached a point that they could put this pain and trauma behind them, but we still changed the law. The United States Supreme Court required that mandatory life without parole be reversed, and that all these defendants come for resentencing, despite the pain that they acknowledge it would cause. In civil cases, Your Honor, sanctions are imposed to punish and deter.
I missed a Nick Staroff raid. If you guys are here from Nick, awesome, cool. I just realized that happened, and sorry I missed it, Nick, earlier.
And all you're dealing with is money. This is a criminal case. This is a man's liberty. It is his freedom. It is his ability to live outside the prison walls. If Your Honor does not grant a new trial, you send a message to Karen McDonald and to her office that you will, and that the courts will, tolerate this type of misconduct, this type of constitutional violation. And perhaps even more troubling, you send a message to prosecutors throughout this state that failing to disclose Brady material, information that is critical to a defendant's meaningful right to cross-examination, will not be sanctioned, Your Honor. Mr. Crumbley is entitled to a discovery remedy. The only remedy that can make him whole is a new trial, Your Honor. Thank you.
Thank you. Anything, Mr. Keese?
Just briefly, Judge. Just throughout today's argument, I feel that
I am
my
offended.
responses have been measured, and I've said over and over again that is one thing to argue
I
the law,
am
is quite another
angry.
to throw around unfounded allegations. And I sincerely take issue with the fact or the allegation that we prosecute for headlines. We prosecute for victims, Judge, for victims. That's why we're here, and that's why we do this job. James Crumbley was convicted because of the choices that he made, the choices that led directly to the deaths of Hannah, of Madison, of Tate, and Injustice.
Yep, gotta name the
Crumbly's
victims.
Gross negligence. It was James Crumbley's causation and his foreseeability that was the reason for his conviction, Judge. The evidence in this case was overwhelming. I simply ask that this court review the law, follow the law, Judge. Our brief is detailed. Our argument, I believe, is clear. Thank you.
Thank you. I don't think you can expect something from me in less than a month, probably. I'll do my best.
Yeah,
but I'm
headlines are just
being
the
very
bonus.
careful, and
That's right.
sometimes I think some of my other 550 cases have taken a back seat to these two cases in the last 3.5 years. So I will do my best to get back to you as soon as possible. All right?
Yeah, he's very agitated.
All right.
All right. So that was the hearing that happened on Friday. If I put my fortune telling hat on for a second, my prediction is that it's going to go nowhere. The court is going to deny everything. It's interesting that Judge Matthews has decided to wait for this hearing before she issues an opinion on both cases, but that's what she's doing. So we should have an opinion fairly shortly. I will try to put a stream together when we go over that. Also, on Tuesday at 5 p.m. Eastern, myself, Nick Staroff, and Andrew Branca, self-defense expert, we'll be talking about another Michigan case. That is Christopher Schur, the Grand Rapids police officer who shot and killed a suspect and is on trial for murder. His trial is starting on April 28th. We will be following that and streaming that live right here on Making Law Simple. But we're going to do a sort of a preview stream where we're going to talk about whether or not it actually was self-defense. Now, my opinion is I don't feel like they're going to be successful with the self-defense case, but Andrew Branca believes that it's self-defense. So it'll be interesting to have him on, and we'll talk about that on Tuesday. Will you be doing any Karen Reed updates? I will not be doing any Karen Reed updates. I've never really covered the trial. The only part of the Karen Reed saga that I covered was Turtle Boy because I found that fascinating. So I might be doing some Turtle Boy stuff, but not Karen Reed. I'll leave that over to the Broken Baker. If Wendy or somebody could throw in a link to the Broken Baker, who's been covering the Karen Reed saga, I would defer to him. He is the one in the know on all of that. And I'll be watching the Karen Reed trial over with him. So I recommend you all do it as well. Let's see. Not issuing her decision, and Jennifer seems like she's just being polite. Well, I don't think she wants to issue contradictory opinions. I don't think she wants to say no to Jennifer, but yes to James or something like that. I think she wanted to let all the arguments in on both cases and then issue her two separate opinions, which are basically going to be identical to each other. But yeah, no, so interesting. While we were watching this case develop, after the preliminary examination, while we were ramping up to trial, and even during trial, a lot of parents out there were fairly concerned as how are they going to use this? How is this going to open a precedent to charging parents with all kinds of things? And one of the examples that we talked about, the slippery slope example that we talked about, was let's suppose you own a vehicle and you give it to your child, right? Because supposedly these parents gave their son Ethan a gun, right? And I said, well, did they really give it to him, or is it owned by the parents but they're letting him use it? Much like a car. So if you buy a car in your name for your now 16-year-old and you give them a car, it's not really owned in their name because they can't they can't enter into contracts and own vehicles like that. It's owned by you. You're letting them use it. And you can put restrictions on that. Same way you can with a firearm, right? It's illegal to have a kid own a gun, but you can say, hey, I'm going to buy a gun for you to use. And, when and where I tell you it's appropriate. But then let's assume that kid steals that car and then runs down a bunch of people. Well, would the parents be guilty? Should they be guilty? Should you be able to prosecute the parents if a 16-year-old takes the car that you gave them and goes and runs down a bunch of people? And everyone, even the people that think that James and Jennifer Crumbley should be guilty, kind of had the like, well, no, probably not. Well, here we go. Grosse Pointe teen charged in November fatal crash. Now, this happened in March of 2024. 17-year-old, whose name has not been released. I'm not going to name his name, but I do know. And interesting, I have sort of he's like 3 degrees away from me, so I do know the kid to some extent, like friend of a friend of a friend kind of thing. Anyways, so he's charged because he's out running around in the middle of the night, and he hits a utility pole, killing one of his passengers. So he is charged. This juvenile, this 16 or 17-year-old at the time, is charged with causing his friend's death. All right, so this is developing in March of 2024. Then, in the wake of James and Jennifer's guilty conviction, there was a press for the parents of the dead teen were pushing the Wayne County prosecutor to issue charges criminally against the parents. Now, this is how they rationalize this. Now, the parents had a 360 app and or Life 360, which is where you can track your kids and things like that. I have it for mine, but you can also track their driving speeds and things like that. Apparently, the mother texted the son at one point, was it the driver, and said, slow down, you're driving too fast, or just slow down, or something like that. And then afterwards, bought her son a nice sports car. Now, Grosse Pointe is a very ritzy neighborhood here in Southeast Michigan. If you have money, you're living in Grosse Pointe. These are not middle class. These are not necessarily even upper middle class. These are very wealthy people that live in this area. Presumably, the parents are also very wealthy. So they buy their kids a nice, flashy sports car. And the parents are saying that the parents of the dead teen and the injured teens are saying, charge the parents of this driver just the same way you charge, or the Oakland County prosecutor charged James and Jennifer Crumbley for causing the death of my child. And the Wayne County prosecutor came out in December and said, no charges against the Grosse Pointe mother whose son is accused of murder in a fatal car crash. And so they investigated it, though. And this is why if you were here last week or 2 weeks ago when we were talking about the Diddy stuff and all these accusations against Wayne County prosecutor Kim Worthy, and potentially criminal Sean was like, yeah, she's still a prosecutor, she's a little shady. I gave her props and I said, I like this prosecutor because she's not afraid to say, no, we're not going to bring political charges. Let's see. Grosse Pointe blank. Is it the same Grosse Pointe? It's not Grosse Pointe, Michigan, is it? To make out with at 24. No, I wouldn't go to Grosse Pointe. Is it really? Okay. I'll have to check that out. I didn't know it was the same Grosse Pointe. So you might know Grosse Pointe from Bob Bashara. If you guys want to look up an interesting Grosse Pointe case, Bob Bashara had his wife killed by his, we'll say, mentally feeble handyman because she caught on to the fact that he had a sex dungeon in his basement and he was known as Master Bob in some sort of BDS ring around Grosse Pointe. This was a guy that he didn't fit on the cover of a romance novel. He was just too big for it. So if you guys want to look up that case, Bob Bashara, and that was an insane case. Master Bob. Maybe if you Google Master Bob from Grosse Pointe, you might be able to find that. So anyway, so this is the points. This is where all this stuff, yes. Sex dungeons are not the problem. Yeah. It wasn't the sex dungeon. It was the contracting to unalive your wife. That was the problem. Anyway, so the Wayne County prosecutor said, no, we're not bringing charges. So the mother of the victim, 18-year-old Flynn of Grosse Pointe, told the Detroit News that she was disappointed in Kim Worthy's decision. She said that she wanted the prosecutor to charge the driver's mother under the legal precedent that was set after the parents of the Oxford school shooter, Ethan Crumbley, was convicted of involuntary manslaughter. This is the slippery slope, right? This is one of the things that we talked about during this trial. Thankfully, Kim Worthy said no to this. But do you think Karen Reed would have said no? If this had happened just a few miles down the road, it would have been in Oakland County. Do you believe Karen Reed would have said no? In separate trials this year, James and Jennifer Crumbley were found to have been grossly negligent in providing their 15-year-old son with a gun he used to kill 4 students. Let's see. We don't need to go through the names. Let's see. McKinley's mother, Anna, told the News that she thought there was enough evidence to prove the driver's mother knew he was reckless because the Grosse Pointe Farms police report showed that the woman had monitored her son's driving via a Life 360 app and allows parents to view their kids' driving speed, hard braking, and other activity. But Worthy said in a press release Tuesday that she determined after lengthy investigation there wasn't enough evidence to charge the defendant's mother. Worthy said the victim's mother sent her a letter asking that the defendant's mother also be charged. The woman alleged inaction and negligence on the part regarding her son's driving ability, the release says. Let's see here. Worthy said she launched an investigation into the defendant's mother. On August 15, 2024, a warrant request was presented to Wayne County Prosecutor's Office, an extensive review of records and evidence over a period from 2018 until 2023. So they did their investigation. All of this mother's text messages and data and everything were looked into. This was done to get a full picture of the relevant facts and evidence pertaining to the mother's conduct relating to the respondent over a period of a year leading up to the fatal crash. The result of the review, Wayne County Prosecutor Office has found that the respondent's mother has consistently taken reasonable measures to assert parental control over her son over the years as it relates to the general behavior of his driving leading up to the crash. All right. So what they're saying here is that because the mother consistently asserted parental control, I don't know what that means, over the years as it relates to the general behavior of his driving leading up to the fatal car crash. I don't know what that means. I don't know if that's grounding him, taking away his keys, telling him, no, don't do that again. I don't know what that means. But we have an elected prosecutor post-issue evaluating this mother's parenting skills and assessed it to be worthy. The parenting expressed by this mother was worthy of our standards. Therefore, there shall be no prosecution of this mother. What the hell does that mean? As a general rule, you should be able to know what your standard of conduct is. It is illegal to consume certain drugs. Okay, I know that. I shall not consume certain drugs, and if I do, then I will be committing a crime. Well, what is the crime here that we're trying to prevent? General exercise control over her son over the years as it relates to general behavior of the driving leading up to the fatal car crash. What does that mean? How should I conform my behavior as a parent so that I know when some prosecutor down the road might be looking at my actions to assess whether or not it's deemed worthy in the eyes of the state? A hint would be great. Parenting is hard in the best of circumstances. That I agree with. Most parents do everything they can to monitor their children and steer them in the right direction. I agree with that. The juvenile respondent's mother was no different. She took consistent, active steps to try to make sure that he stayed on the right path. Okay, I agree with everything Kim Worthy says in this in her press release, and I'm not criticizing Kim Worthy for this situation. I'm praising her for having the foresight and not bringing charges here. But this is the issue with this type of case. You're assessed after the fact, and if you did right as a parent in the eyes of the state, then you're fine. But you don't know until afterwards, and it's judged by somebody who's essentially deciding on their own. There will be those that say she should have done more. But we have looked at all the facts, and those facts dictate no criminal charges here. So we will not have more we will not be more specific about her actions because her son will be facing trial in February. Now, he ended up pleading guilty, so we didn't have a trial. So we probably will never know exactly what the assessment was, because who knows? There could be appellate issues on the sentencing and then trial set and things like that. We're not going to know what exactly was the basis for this. But this is my problem. But we used it as a specific example during this trial that any action that your children take could come back and lead to criminal prosecution against the parents if in the eyes of the state they were not appropriate actions. It's just a very slippery slope. And I hope there's some very, very, very narrow tailored opinions from the Court of Appeals once James and Jennifer Crumbley's case gets there, if not the state Supreme Court. Yeah, we were all worried about that. Yeah, I agree. So, but I wanted to highlight this mainly because I wanted to praise Kim Worthy for not bringing charges against the mother in this case. I think that was an appropriate decision. But I also wanted to use it to highlight where we could potentially go as a result of this. I told you all that this was a bad way to go. Now, speaking more to the actual merits of the argument, I think in the James and Jennifer Crumbley case, I think one of the most fundamental issues is the confrontation clause. In both cases, now the text messages were different, the journal entrances were different. I don't think they brought the journals in under Jennifer, but they did under James, or vice versa. I can't remember exactly what it was. But allowing written statements from a witness to be introduced without the ability to cross-examine the author of those statements is a huge issue. So whatever you want to say about Ethan being allowed to testify, being compelled to testify, not testifying, or his mental health records coming in or not coming in or any of that stuff, if you cannot confront the author, then it shouldn't have been allowed for the state. The state was allowed to introduce the statements without allowing the defense to cross-examine those statements. And that is, if both of these cases get new trials, or at least one of them does, that's my prediction as to the grounds, is that you allow these statements in without the ability to cross-examine them. And I think that's the worst thing that was done in this case. Beyond even trying them, the idea that you can introduce hearsay statements, because they are hearsay statements, without authentication, because the witness wasn't there to authenticate them and say, yes, I wrote these. And then also without allowing the cross-examination of that witness, that's a huge issue that just stretches across all kinds of other criminal matters. So, but what do you guys have to say? At least till they start forcing parents to download an app. Yeah, well, they're going to start forcing parents to download an app and then telling them how to respond. Why don't we just let the state parent all the kids? Why don't we just do that and be like, you tell me how to do this. What is the appropriate amount of length of grounding per situation? We should just have the state just sort of put together a checklist. I think that'd be fine. He may have written it, but we don't know if it's truthful. Yeah, that's the other thing too. When he tells his friends that he wants to go pew-pew at school, when he says it, or his one friend, and he says it via text message, is he serious? Do we know if your parents ever saw it? Did you ever tell your parents? Did your friends tell your parents? That was the other thing too, is they allowed text messages between James and Ethan's friend's dad. Those text messages came in, which is fine because James is there if you want to introduce the statements, but they didn't introduce them by Ethan's friend's dad. He wasn't called to the stand. And to the extent that they conveyed information, you have quadruple hearsay. You have a statement from Ethan being related to the friend, being related to the father of the friend, being related then to the defendant. So you have like 4 levels of hearsay there. It was all kinds of bad. So anyways, that is my stream for today. I'll be back on Tuesday, like I said, with Nick Staroff and Andrew Branca to talk about the Christopher Schur case, potential self-defense of a cop that shot a suspect in the back of the head while he was on top of him. I'm having a hard time with it. I'm having a hard time with self-defense, but I'm curious to see what Andrew has to say. And then starting April 28th, Nick and I will be dual streaming the trial of Michigan v. Christopher Schur. Yeah. Very interesting stuff, not covered anywhere else. That's right. That's why you come to me. And also, always free Zachary Anderson. All right, I'm going to send you guys over to Dolly's stream for tomorrow. Hit the notification button. Hit the subscribe button. He's a little weird, but we like him anyways. Go say hi to him in the chat. And I noticed a lot of people coming in late saying you didn't get notifications. I don't know what to do about that other than try hitting the notification button for the live stream, because I've seen that that's done a lot better. If you're subscribed and you click the bell and you do all that, but if you actually go to an upcoming stream and you click the notification button, that's never failed me. I always get notifications. So I will shut up, Farrell. I will leave you guys to the rest of your Sunday. Have a wonderful Sunday. Thanks for all the new people and all the returner people, including Farrell. I guess I can thank her for being here for a hot second. And y'all have a good day. Oh, I'm frozen.
When I was young, my dad